Good morning and welcome. Thanks to those of you who are attending here in person and to the more than 200 joining us today across the province by webcast. It's amazing what an offer of free CBD will do to get people together. So I'd like to first recognize that we're situated within the Dish with One Spoon Treaty territory. I would also like to acknowledge that we are situated on the ancestral territories of Anishinaabe and the Haudenosaunee. In particular, I'd like to acknowledge the Mississaugas of the New Credit First Nation and the fact that Toronto has historically and continues to be a sacred gathering place for Indigenous people. In addition to acknowledging the land, I also want to thank and acknowledge my co-chair, Jill Witkin, to my left, chair of the Sexual Violence Advisory Group at the Ministry of the Attorney General, Brina Parnez, Counsel of the Victim and Vulnerable Person Division, and the rest of the MAG team for helping to organize this conference, along with the Criminal Lawyers Association. Jill and I also co-authored a book called Prosecuting and Defending Sexual Offense Cases from Eamon Publishing, which we are contractually obligated to plug and endorse at every opportunity we get. As we can both attest, the law surrounding sexual offense cases has gone through some significant changes over the last few years. And in addition to educating all of you here today about some of those changes, I could let you know that Jill and I are also furiously working towards the second edition of the book, which we expect will be out later on this spring. The book will also include a new chapter on Bill C-51 and a revised chapter on representing victims in criminal cases, and we hope it'll be a useful tool for everyone involved in the justice system. As you know, today's conference is about representing sexual assault victims in criminal cases. In 2015, the Canadian Victims' Bill of Rights and the Canadian Code redefined the term victim to include those who have suffered physical or emotional harm as a result of the commission of an offense or an alleged offense. And so legally speaking, when we use the term victim, we're now using that term interchangeably with complainant. Victims of crime have received far more attention and status in criminal cases in recent years. Beyond the rights enshrined in the Victims' Bill of Rights, which primarily relates to sentencing, Bill C-51's amendments to the 276 and 278 regimes regarding prior sexual history and private records have now given victims and their lawyers standing at those hearings to make submissions and perhaps even participate in cross-examination. While the scope of victim participation in 276 and 278 hearings remains undefined precisely, what is clear is that victims and their counsel play a far more significant role today in the criminal court process than ever before. The goal of today's conference is to review some of these important legislative changes and to educate lawyers who may consider representing victims in criminal cases. It's in everyone's interest, including the Crown and the defense bar, to ensure that criminal cases run smoothly and efficiently. Having a skilled, experienced, and educated lawyer representing a victim can ensure that motions under Section 276 and 278 remain focused and remain on track. And it's the reason why the Criminal Lawyers Association and the Ministry of the Attorney General has teamed up here today to bring you this program. While the Crown and defense sit on opposite sides of the courtroom as adversaries, we can all still learn from each other and achieve common goals to raise the bar when it comes to the prosecution and defense of sexual offense cases. We hope that by the end of today's session, you'll have a better understanding of the Bill C-51 amendments, how to litigate the use of private records under Section 278.94, and how to best represent Indigenous victims. You'll also hear from some very experienced counsel today who will review the best practices and tips for success in these hearings. Lastly, and perhaps most importantly, you'll learn how counsel can get hired and paid through Legal Aid Ontario to provide representation to victims on these types of hearings. So given how much we hope to cover over the next 4 hours, we're going to be limited somewhat in the way we can answer questions directly, especially through the webcast process. So we will still encourage people in the room. You can ask some questions, but otherwise, Jill and I are going to make our email addresses available, and you can email us directly if you have any lingering questions after the end of the hearings, which we can direct either to ourselves or to the panel members. So I now turn the floor over to my co-chair, Jill Witkin, and to Megan Savard, who's defense counsel at Adaria Law Group, for an overview of Bill C-51's legislative changes to the Criminal Code.
Thank you, and thank you everyone for attending, and thank you for those of you in your pajamas who are watching from afar. Megan and I are going to do the first presentation, and then we've got two esteemed counsel, Crown and counsel at the end, who I will introduce later, and they will do the case law part of the presentation. Daniel's already given you an introduction to who I am. I've been a Crown for 26 years in downtown Toronto. I'm now at the Crown Law Office Criminal, and I do sit as the chair of the Sexual Violence Advisory Group, and I do a lot of these types of presentations. Megan?
I'll say I need no introduction, mostly because I don't have one prepared. I'm a defense lawyer at Addario Law Group, and a large portion of my practice has always been devoted to defending sexual violence, sexual offense cases. I also represent complainants, and I think in that dual role can probably add a little bit to the discussion here today. And I'd say that a significant portion of my practice that has always been devoted to criminal defense of sexual offense cases has only gone up since Bill C-51 doubled or tripled the number of pretrial hearings in almost every single case.
So what we're going to do in the next few hours is we're going to try to give you an overview of what Bill C-51 is, how it impacts sexual assault cases. We're going to talk a little bit about also some recent case law from Section 276. And hopefully we'll have answered most of your questions, and at the end, if there is time, we do encourage people in the room to ask questions, and people on webcast, you can send them in after to Daniel or myself. So let's just start with the first slide that reminds everybody that Section 276 is essentially what's known as the Rape Shield Laws. And that means that evidence of the complainant's other sexual history may not be adduced by the accused in order to encourage the inference that she's more likely to have consented to the sexual activity that's in question, or that she's less worthy of belief on account of her sexual history. That has been in place for 2 decades. Everybody is well aware of that. What has Bill C-51 done to change that? So there's 2 things that Bill C-51 statutorily added to the criminal code, which affects 276. And the first is that, and certainly clients that are, complainants counsel who are advising clients need to know this because they need to know what sort of evidence is captured by Section 276 and what admissibility test applies. So first of all, under 276.1, and that was the last slide I had up, evidence can't go in for the inference that the complainant is more likely to have consented or less worthy of belief. But 276 sub 2 is the factors that have to be considered by a judge to determine whether or not the evidence will be admissible. And 276.2 sub A is essentially a categorical reminder to judges that that evidence cannot be adduced for a prohibited purpose. So before Bill C-51, it had to be relevant to an issue at trial, it had to be of specific instances of sexual activity, and probative value had to not be substantially outweighed by prejudice. Now there's an added subsection, and that's that it is not adduced for a prohibited purpose. And that's really to remind, to focus everybody to ensure that that doesn't happen. The other thing that's added to Section 276 is that the type of sexual activity that's covered now specifically includes any communication that's made for a sexual purpose or whose content is of a sexual nature. And prior to Bill C-51, there was case law which interpreted what type of sexual activity would be included, and it was held, for instance, that discussions about threesomes or a complainant who was posting sexual content on her social media feed would be covered under Section 276. So now the legislation codifies that. Sometimes it might be debatable whether a communication meets this definition. So a bikini picture sent by text, maybe there's a difference if somebody, if a complainant is sending an accused, let's say, a text of a close-up of her bikini top with maybe a sexual comment or a look in her face that suggests sexuality, versus a complainant who is sending a picture of her in a bikini at a beach playing volleyball in her Birkenstocks. That may not be covered under this section. So it's just going to depend. Okay, so now we're just going to take a brief interlude, and we're going to very quickly talk about some of the 3 cases that came out in the last year, essentially. They all came out in 2019 from the Supreme Court of Canada, and they all touch on Section 276. And this is the first time in 2 decades that the Supreme Court of Canada has actually dealt with 276. The case of Dara, which was, I think, in the early 90s, that was the last time. So they have a lot to say. And I'm going to turn it over to Megan to talk about Barton.
Does anyone not know about Barton? Do I have to go over the facts? It's a very famous call to action by the Supreme Court of Canada arising from the notorious Bradley Barton murder case, now manslaughter case, involving the death of Cindy Gladue, who is an Indigenous sex worker. And the important thing about Barton for the purpose of this conference is that it dealt with, among a number of different topics in sexual assault law, the scope and process that should be followed in 276 hearings. The relevant factual background there is that because this was a murder case and not a case where a sexual crime was particularized on the indictment, no one really turned their mind to the possibility that a pretrial admissibility hearing might be required. And as a result, the Crown, the defense, and the trial judge all introduced and relied on, respectively, sexual activity evidence that may have been admissible. The Supreme Court of Canada was actually very careful not to rule on the admissibility of the sexual activity evidence that should have been subject to a hearing, but it all went in without the kind of scrutiny for which the 276 regime was created. The couple of points to note with Barton, we can go to the next slide, is that the Supreme Court was dealing with a 276 regime in which complainants' counsel did not have a role, or at least not a statutorily identified role. And so in that call to action where it said everyone involved in the justice system has to be conscious of and respectful of the rights of witnesses, now, despite the fact that Cindy Gladue is definitely the victim of something, I'm going to use the term complainants. I realize that as a matter of policy, they might be interchangeable, but in a fact-specific scenario, when you go into court and someone is presumed innocent, you may get yelled at by the trial judge for using the term victim. So unless I'm talking specifically about the post-conviction stage, I'm going to use the term complainant, which is still practice in the trial courts. The call to action was for the people currently involved in the 276, 278.94 process, trial judge, defense counsel, Crown. And there's a couple of things that arise from that that are relevant as a matter of policy. First of all, it's a reminder that if everyone is doing their job properly, there should be no improper disrespect for complainants' rights. The problem in Barton is not that the legislation was flawed, and some would say that Bill C-51 was a bit of a if it ain't broke, don't fix it problem that could have been better solved by educating justice system participants. The idea underlying Barton is that even in the prior regime, if everyone had been doing their job properly, Cindy Gladue's rights would have been respected. And so when you come in as complainants' counsel into a case that's already been pre-tried, where the Crown and the defense lawyer may have a relationship, where the trial judge may already be more familiar with the case than you are, an important philosophical approach is to go in not thinking that any particular person is the adversary. I often find that in these cases, the complainants' counsel reaches out to the Crown, and not to me, which I find a little interesting because oftentimes I know a lot more about the motion I'm bringing than the Crown does. And in many cases, I'm willing to share anything that's not privileged and not going to compromise my client's defense. But I'm always surprised by how complainants' counsel don't reach out to defense counsel. And there shouldn't be any bar to at least doing so if you accept that philosophically we all want the same thing here, which is not to gratuitously embarrass anyone. Let's see if we can go on to the next slide. Oh, and by the way, just as a practical point, if you do write only to Crown Counsel, I'm going to seek disclosure of your emails, so you better be nice about me. The other thing Barton identifies for us is that 276 is really, it's more purposive than some might have thought. And so although this was a murder case and it wasn't strictly the type of offense for which a 276 hearing would be required, Barton expanded or clarified, depending on your view, the scope of 276 and made it clear that any offense that has a connection to a sexual offense of some kind is going to be covered by the regime. And that, I think, for the purposes of this conference, only raises one interesting point, which is, do you, as complainants counsel, have a role in Barton? In a case where the person has died and their interests may be implicated, but they're not someone who can instruct counsel or appear and make submissions, which is what the legislation permits. Is there a role for complainants counsel? I think many defense counsel would say no, but that illustrates the point I made earlier, which is that if everyone is doing their job properly, complainants counsel is not, they're not an essential cog in the wheel. Your job really, I'm not going to say it's superfluous, but it has number one, symbolic value, and number two, historical value, in the sense that we don't always do our jobs, and sometimes we do need you there to make sure we do it. So those are just a couple of things arising from Barton. Yeah.
Okay, so now we're going to go on to Goldfinch. This was the second case in 2019 of the trilogy, and this was a case that dealt with sexual relationship evidence. And the facts here, very briefly, were that accused and complainant had been in a relationship, they had broken up, and they were then, after the breakup, friends with benefits. They often would have sleepovers, and they would have sexual activity, and defense wanted the evidence of their friends with benefits status at this point in time when the alleged offense occurred to go before the jury. The defense felt that the jury would need that evidence in order to dispel the inference that the complainant would have consented out of the blue. So ended up going up to the Supreme Court of Canada, and there were two concurring majority judgments, one written by Justice Karakatsanis with the majority, and then Justice Moldaver and one other judge who wrote a concurring judgment. And really, at the end of the day, all of those majority judgments, the result was that sexual relationship evidence should really only rarely be admitted. And it'll be admitted in very exceptional circumstances. For example, if it's fundamental to the coherence of the defense narrative. And in Justice Moldaver's judgment, he posed the possibility that if the application had been properly brought, and if the, for instance, application demonstrated that the accused needed that evidence because there was a piece of evidence where the accused testified that he had mouthed to the complainant. She was in his apartment, he was on the stairs, and he mouthed to her, "I want to fuck you." And Justice Moldaver posed that he may need that evidence in order to prevent the jury from thinking that he was a menace or a creep, or thinking it was completely unreasonable that that would occur. But it would have to be framed in that context, that he absolutely needed that evidence in order to advance his defense. Another example would be if the complainant puts the sexual nature of the relationship in issue. So that happened in Harris. If the complainant in her police statement, for instance, says that the relationship was platonic, but in fact there is evidence that there was a sexual relationship, well, that would be used for impeachment purposes, and that may certainly be an admissible avenue of sexual relationship evidence under 276. The third example would be how the complainant previously communicated consent, and that would be to support the accused's assertion of honest but mistaken belief in communicated consent. So example, if there was a dominant submissive role playing, if the word no was a sexy word as opposed to a safe word, for instance, that might be admissible. But by and large, bold statements that it has to go to credibility or narrative or context, just put out like that boldly without any other explanation, is not going to render it admissible. And the court really talked about the fact that the accused has to identify with precision what the relevant use of that evidence is. And also, what is the relevant use of the sexual part of that evidence? Because in this case, the Crown was willing to admit evidence that the couple had sleepovers at this point in time. They were in a good relationship, and they would sometimes have sleepovers, and the jury could infer whatever they wanted to infer. But the issue was, does their actual sexual relationship need to go before the jury? So that's what's going to be considered going forward. And obviously, it's twin myth reasoning. We know that just because a complainant has been intimate with an accused person in the past, that it's more probable that she would have done so again. And Megan would certainly say that evidence that's otherwise inadmissible to prove plausibility may be admissible to rebut a Crown claim of implausibility.
Can I say something that might be relevant to complainants counsel on this point? I actually think it is good practice in light of what Jill just said, that evidence of plausibility might be admissible to rebut a claim of implausibility. I think it's useful for defense counsel to write to the Crown as early as possible in a case and say, are you intending to introduce anything about plausibility or anything about the complainant's propensity to engage in the type of activity or the activity in question with this type of person? Because if so, I want to know before the judicial pretrial if I need to bring a 276 application. And I mention this now only because for those of you who might get involved early on in the life of a case, if you have a complainant who's approached you before there's an order appointing counsel, for example, you might have a role to play in that discussion. As an example, I was dealing as complainant's counsel in a case that involved a Crown of a particular age and gender, and the intent of the Crown was to introduce evidence of the complainant's off-indictment sexual activity for what I thought was no discernible reason. And as complainant's counsel, I was able to point out that this might actually create a 276 application where none was required, and then the Crown decided ultimately not to introduce that evidence as part of its case. So that's sort of, for the purposes of this conference, a useful thing to think about if you're involved at that stage of the case, whether you can be involved.
Okay, and this actually takes me to the next point from Goldfinch, which is that 276 sub 2, the legislation applies to the accused. So if the accused wants to adduce in any way, shape, or form, whether it's through the accused or cross-examination or other witnesses, if they want to adduce other sexual history of the complainant, they're going to have to bring an application under 276 sub 2. The Crown is not bound by the legislation, but what the court in Barton and in Goldfinch said was that if the Crown wants to lead other sexual activity evidence, that's governed by the principles in C. Boyer, which essentially is the evidence has to be relevant, probative value has to outweigh the prejudicial effect, and everyone has to be clear of that. So what Crowns are being told to do is at a very early stage, figure out if you yourself as the Crown are going to lead other sexual history evidence, and you may, in order to develop the narrative, the complainant may, in certain cases, need to refer to maybe something that happened 2 hours before in order to contextualize their evidence. And if we're going to, then what the Crown does is let everybody know, let the defense know in writing, let the court know either through a JPT or at the beginning of the case. And that at least lets defense know if the Crown is leading a certain piece of evidence, they're entitled to cross-examine on that piece of evidence. If they want to go beyond that, they'll bring an application. But it lets everyone know at the beginning what evidence is going in, that it's not going in for a prohibited purpose, what the relevance is, and everybody starts on the same foot. And so that's something that has to be kept in mind. And now, I should say I know that I think Justice Duty might have said something a little bit different in Boyle, but I certainly don't take the position from the reading of the legislation that complainants' counsel have a role to play if the Crown wants to lead other sexual activity evidence. In other words, complainants' counsel, it doesn't appear, has standing if there were to be a C. Boyer application. Their standing is limited to a 276 application.
Technically, they also don't have standing in constitutional challenges and motions for direction, and yet here you all are showing up at both of those. So I would say you can seek standing, but just make sure you're familiar with the common law test for intervention, because you might be asked outside of the statutory context, why exactly are you here? And what gives me, the trial judge, the authority to authorize you to make submissions or say anything at this different stage of the proceeding?
So I'm going to move on because we're running out of time, and maybe Megan, just very, very quickly, RV is the third case of the trilogy.
Yeah, that's fine. I don't like talking about this case because it's wrongly decided. And full disclosure, also my case. It doesn't change much. The law as of C. Boyer was that if the Crown alleges that the physical consequences of a sexual offense were caused by the defendant will almost always succeed on a 276 application to show that other possible causes were in the mix and raise a doubt about that. RV was a case where the Crown relied on the complainant's pregnancy because the complainant had said she was previously a virgin to corroborate the allegation that there was, in fact, a rape. And the main usefulness of this case, it kind of goes back to what we were both saying. The Crown should be very clear at the outset about, and thoughtful at the outset about what exactly it needs to put in order to prove its case, because it was the fact that the Crown relied on the pregnancy that opened up the door to this 276 and became the hook for admissibility. So This case, because virginity was in play, that it made sense for the Crown to do so. But if, say, you've got a sexually active complainant and the issue of pregnancy is not corroborative to the same extent, then the Crown could have avoided the whole situation in RV by simply not introducing the fact that the complainant got pregnant until the sentencing stage, at which point they might have something to say about whether or not that's aggravating.
Okay, so now we're going to move on to what you're probably more here to hear about, which is the new record screening regime under 278.92. I think this is go quickly.
One of the major changes that was wrought by Bill C-51 is what Jill and I have called the record screening regime, and it creates a new form of pretrial admissibility application that has nothing to do with off indictment sexual activity evidence. It's about the complainant's private records in the possession of the defendant. It now is treated, these private records are treated in the same way, subject to a slightly different test as sexual history evidence, in that they are the subject of a pretrial admissibility screening regime, and the complainant has a right to participate at the stage 2 hearing about whether or not private records will be admissible. The 2 sections you need to know in order to assess whether or not the pretrial screening regime might apply are 278.92, which says that no record in the possession or control of the accused shall be admitted into evidence if it belongs to the complainant, unless the pretrial admissibility regime is followed. And then secondly, I don't know which slide we're on right now, the previous slide.
Okay.
Secondly, 278.1, which defines what counts as a record for the purpose of triggering the section. It's a non-exhaustive list of records. They are mostly focused on records created in circumstances where nobody but the complainant or her confidential professional was intended to see them. And I know there's a whole debate out there about whether text messages count as records for the purpose of that section. I'll leave that aside, and maybe
The next panel's going to talk.
the next panel will talk about that, but let's talk about something that's totally unrelated and maybe more current. Let's imagine that the complainant and defendant have a shared computer, and the complainant has got her login credentials auto-saved on the computer. There's an allegation, and she leaves the house, and the defense says, oh, this is interesting, logs into her social media account and starts pulling stuff off there. That, to me, that's the kind of record that is undoubtedly meant to be captured by this section. And we spend a lot of time fighting about gray areas, but but it's the kind of thing now where the complainant's counsel is involved to identify particular privacy and dignity concerns that might arise out of a situation like that. The record screening regime has a number of factors to consider for the trial judge to consider before they can admit private records. They're on the screen in front of you, so I'm not going to list them. What I will say is, as complainant's counsel, you should turn your mind to which factors you in particular can provide the most useful input on. So it may be that in most cases, the Crown can cover off the interests of justice and the right of the defendant to make full answer in defense. It might not be for counsel for a witness to weigh in about the relevance of a piece of evidence that's being put forward to be admitted, but definitely you'll want to make submissions on factor G, which is the potential prejudice to the complainant's personal dignity and right to privacy. So being able to tether your submissions and any evidence you might call to one of those factors, maybe most often G, that's going to be helpful to the trial judge, and also it's something that defense counsel is less likely to object to. To use the example that we're going with now, the login credentials, it may not be known to anyone but you and your client that this is how the defense got access to all of these records. And so you would be the one who could introduce evidence of that fact. And that's sort of a very nice concrete way in which complainant's counsel could play a useful role.
Because remember, complainant's counsel, you're going to have a confidential relationship with your client. The Crown, of course, doesn't have that confidential relationship. And it may be that pre-Bill C-51, the complainant may not have been comfortable saying certain things to the Crown or talking about certain things to the Crown, where they would more likely be comfortable speaking to complainant's counsel. So I agree with Megan. I think it depends on the case. It may be in some cases complainant's counsel will have something to say about about relevance or about the reasonable prospect that the evidence will assist in the just determination, that remains to be seen, but certainly ones that are more specific to the complainant about prejudice and personal dignity, those would definitely be in your domain. Now, we've sort of touched on these, but I think now just want to go over so that you all are aware of the new procedures. So, prior to Bill C-51, 276 had procedures that had to be followed, and those were formally Section 276.1 and 276.2. Those now no longer exist, and the new procedures that apply to both a 276 hearing and this new private records screening regime are found in Section 278.93 and 94 of the Criminal Code, and those are the new provisions that have come with Bill C-51. So it's pretty confusing, because if you're in a 276 application, you're looking at 276 sub 1 and sub 2, and now you got to flip ahead to 278.93 and 4 to figure out what the procedures are. But as long as you know that these, what I'm going to talk about here, apply to both sets of applications. And so it's a two-stage process. 276 used to technically be two stages, but they were often collapsed into one. But now, because complainants' counsel have a role at the second stage, they're clearly split. So the first stage is the application stage. And the application has to be made in writing by defense with detailed particulars of the evidence that they're seeking to adduce. They have to articulate what the relevance of the evidence is to an issue at trial. Service has to be on the Crown and the court 7 days in advance, or of course a shorter interval if it's in the interest of justice and if the judge rules. And the evidence has to be capable of being admissible, and I'll come back to that after, but that's something you should remember, capable of being admissible. And this is an in-camera proceeding, so this is in the absence of the public or the jury. This would be the stage 1 proceeding. If the conditions are met, if the judge is satisfied that the conditions are met, then the judge will hold a hearing. And it's only at the second stage, we're going to get to, this is where complainants' counsel come in, as per the legislation. A hearing, which is stage 2, is also going to be conducted in camera, and here the complainant's not compellable, just like she was never compellable on a 276 application or a third-party records application, but she may appear and make submissions. And when I say she, I recognize that it's she or he or a non-binary, but I'm just going to say she for the purposes of this presentation. She may appear and make submissions, and she has a right to counsel. So those submissions may be made by counsel, and the judge has to advise the complainant of the right to counsel. I think practically we don't need to bring the complainant to court for the judge to advise the complainant. I think the Crown can undertake to do that and let the judge know that that's happened. And so really what you have to remember is that, sorry, I'm just going to go back one. These types of two-stage hearings now, where the complainant has a right to appear and make submissions and has a right to counsel, that language there is the exact same as what exists in the third-party record regime. So may appear and make submissions and has the right to counsel is the same in the third-party record regime, and that's where defense is seeking production of a third-party record that they don't have in a sexual assault case, and for 20 years now, the complainant has had the right to participate in that context. So in these 3 different contexts, third-party record production, private record to adduce the private record, and a Section 276 hearing, all 3 of those are where complainants now have standing.
Can I say 2 things just about that? Your client is not compellable, but they are competent. And so I actually think it is good practice in the confidential relationship to at least advise your client about the fact that they are competent. And in many cases, your advice may be to not give evidence, but there may be certain circumstances where there's relevant evidence to give. And we all know that at the type of hearing that we're talking about, the evidence has to be introduced in a form in which it would be admissible at trial. There may be evidence that can only come from your client. And so you have to turn your mind to whether there's some other way of introducing that evidence. Is it necessary? And if there's no other way of introducing that evidence, telling your client about the pros and cons of participating as a witness at the hearing, just a practical tip. And then secondly, the only other difference here between, I know Jill sort of painted with a broad brush and said these applications are just like production applications. There's one important difference, which is on production applications, you have a statutory right to be served with any materials. On these applications, you do not have any such statutory right, and so you may find, and the next panel will talk about, that there's some objection or debate about how much material the complainant should get access to.
Yeah, that's fair. Okay. So at the end of the hearing, the judge is going to determine whether or not all or part of the evidence is admissible under either 276 or the record screening regime under 278.92. Judge will provide reasons orally or in writing, and obviously the reasons have to go back to the factors and state the manner in which the evidence is expected to be relevant. Okay, so now we're going to move into some frequently asked questions, and because we only have 10 minutes left, we're going to maybe do some of these very quickly. Just this is the bottom line, and you got the slide if you want to refer to it, and then some of them we might develop a little bit, but we're going to make sure to give enough time to the next panel. Go ahead.
Are the Bill C-51 amendments retrospective? Answer yes. Next slide.
Okay. You can refer to that.
Unless you really want to know more about it, I don't think there's much debate.
Yeah, there's no debate on that one. So again, this one?
When can an application under 278.93 be brought, either at the trial or at the preliminary hearing? The only exception to that would be is if you are bringing an admissibility application in relation to records that have been produced pursuant to the 278.3 process. You can only get those records at the trial stage, and so then you could only bring an application to use those records at the trial stage.
Right. And there's case law actually that even if you get the record through a production application, in other words, through a third-party record application, technically you still have to bring an application under 278.92 if you want to use that record. In other words, if you want to cross-examine. Defense would still have to bring that application. I would think it would be very streamlined, but technically there is some case law. I think it might be from BC, but it does say that you have to bring it. But we don't have to debate that.
No, and I think you can also try and combine these things where possible. This is another reason to get in touch with both the Crown and the Defense Counsel and see if we can all
we're all in
avoid
the interest, and we're all in the interest. Okay, 10 minutes left. Thank you. We're all in the interest of streamlining. We don't want to drag these things out, and I think if Crown and Complainants Counsel and Defense Counsel can work well together, some of these issues can be streamlined and maybe even certain positions waived. Okay, we've talked about this a little bit, but...
Yeah, so what is the scope of the complainant's participatory rights? We've talked about how there's some debate about what factors under 276.92 sub 3 you might have the most useful submissions to make. You don't have any judicial rulings limiting that, but it's something where if you want to avoid such a ruling, it's useful to turn your mind to which factors your evidence and submissions are going to be tethered to in order to be able to answer the question, how is this useful to me, the trial judge? Do you have a right to cross-examine the defendant? So far, the cases have said yes, but I think there are two interesting points arising. First of all, the well-established rule, you can't cross-examine on issues that are not before the court, so don't get into the merits of the case or you might get your wrist slapped, and if defense counsel are doing their job, their client will not get into the merits of the case in the defendant's affidavit. And introducing evidence, an issue that's not been decided by any court to date is if you, the complainant, want to introduce evidence, do you have a Stinchcombe-like disclosure obligation similar to the Crown? If you are aligned against the defendant in this proceeding, do you also have to provide them with full disclosure of anything you might use to cross-examine them, anything you yourself might want to put into evidence? The issue on which there's some case law that the next panel will talk about is there a right to review defense materials? The answer is, generally speaking, yes, but only to the extent compatible with the right to make full answer in defense, and what that means in any case is going to depend on the facts of that case.
And we just put up some of the cases that do say that the complainant has a right to cross-examine, and the only thing I would say here is obviously it has to be relevant and it can't be repetitive. So generally speaking, if the accused is testifying, for instance, on a 276 application in accordance with his affidavit, the Crown should cross-examine first, and then if there's any residual issues that have to be covered, complainant's counsel could come in at that stage. I think if there is any debate about what the scope of the complainant's participatory rights should be, that should be determined at stage 2, or at least with the complainant's counsel involved. That was a finding in a case called certiorari that the judge wasn't going to make that decision without hearing from the complainant's counsel. So if those issues take place, they could take place at that stage.
And I think I'm just going to disagree with that because that was our case and we might be reading it a bit differently. Context for certiorari is that there was no stage 2 hearing. So there was a motion for directions raising issues about the scope of complainant participation, but also whether an application was required and when. And the ruling was that an application was required, maybe, but it wouldn't crystallize until the middle of trial, if at all, and so it could be brought mid-trial. And at the end of the day, there was never any complainant's counsel involved in that case. So the asterisk there is not determined. I would say the more relevant case is a case called RVSC, which is unreported, unhelpful in that respect, decision by Justice Forstall that talks about whether and in what circumstances motions for directions finally engage the complainant's rights, because that's really the legal test that applies for whether or not you would be talking about some of these exercises of inherent jurisdiction. And I can find the site for anyone who's interested at some other.
Sorry, and I'm going to disagree only because in Actieri, counsel, Ms. Savard, did want a ruling from the court about what the scope of the complainant's rights were in terms of how far their counsel could go at the first stage, and the court did say, well, I'm not going to determine that now. We'll determine that if a hearing is ordered. So yes, a hearing wasn't ultimately ordered, but the court was not willing to make that determination in the absence of complainant's counsel submission. So that's what I meant. Okay, so next slide is, does 276 cover sexual activity proximate to the alleged offense? And this is a very difficult question, and I don't have a full answer for you. It really, the answer is it depends on the facts. 276 only, an application only has to be brought if the sexual activity in question is not part of the incident that's being alleged. And so the question is, well, if something happened an hour before, or half an hour before, or 2 hours before, or 2 days before, is it part of that sexual activity in question such that a 276 application would not have to be brought? And the tenor of the courts at Lennox certainly was one where where the court did say that if there is a gray area, you might want to err on the side of caution and filter it through 276. But I would ask you really to just, in those cases, think about, is it a separate act? Because if it's a separate act, then it's not going to be part of the incident in question, and a 276 application would have to be brought. If it's almost a continuous incident that is continuing throughout the evening, arguably it may be part of the same incident, and maybe the Crown even wants to lead it for narrative.
And in terms of communications, whether or not a conversation about an act that's going to take place in the future counts as part of the transaction when that act becomes the subject of charges. Justice Dawes' case in XC, which the next panel will talk about, that's the case that's really delved into it the most. Yeah. Does the accused have to swear an affidavit for a 276 hearing? No, it could be the computer guy, right? In our example about the login credentials, the defendant doesn't necessarily have to say, here I am, I'm the defendant, here's what I did, and here's the information I got. It could be someone to whom he's handed over the computer and done a forensic analysis. That's the most obvious example of why the defendant might not testify, but in general, the only rule is as long as the evidence is in a form that is admissible at trial, it can be the basis for the 276 ruling.
Normally it'll be the accused who has personal knowledge.
Nope. I'd say about 60% of my cases it's the defendant. 40% there are other ways. And you as complainant have to think about whether you want to cross-examine those witnesses.
Okay, do you want to do this one?
What does it mean to adduce? That's an interesting question, which maybe you won't have to worry about as complainant's counsel.
Yeah.
The schemes, it's important because all of the schemes we've been talking about are triggered by the adducing of evidence, not by defense counsel's knowledge of the information. So in our login credentials example, the defendant can actually go to his lawyer and say, here's what I found, and you can do all the computer investigation stuff. It's only when you actually want to use some of the information that you have to bring an application to introduce them as private records. And generally speaking, using a document to refresh a witness's memory doesn't count as adducing, and using a document just to formulate good faith bases for cross-examination, as long as you're not putting the content of the document to the witness, those do not count as adducing evidence. We'll agree to disagree.
We'll
maybe.
agree. But as a complainant's counsel, you probably don't have to worry about this, so we'll move on. Does the complainant have a right to certiorari? So there's one case, and that's the Boyle case that went up to the Superior Court. Justice Liberté, he acknowledged that technically there was jurisdiction for the complainant to bring certiorari, but he refused to exercise his jurisdiction to review it. He found that post Bill C-51, the complainant has a very robust participatory right in the 276 hearing, and so her rights are adequately protected at that stage, and if she was to have the right to then a review of the 276 decision, it would put her rights essentially above the accused's rights, who doesn't have that ability until the end of the case. And also he talked about the need to avoid delay and prolonging trials. So our feeling is, generally speaking, I don't think that there's going to be a lot of room for certiorari on these.
Yeah, and if you're advising your client, make sure they know the Jordan clock keeps ticking. So if they do want to bring a certiorari, they need to be aware of the risk that that might end in a potential stay of proceedings if it goes above the Jordan ceilings.
Is Bill C-51 constitutional? I could talk for a while about this, but I'm not going to, because you really don't have to know this other than to know that in Ontario, the decision is yes. R versus ARS is one where it was a yes with a qualification, but that's going to be talked about by the next panel. There are some cases outside of Ontario which say no, but for now we're not worrying about those. In Ontario, it is constitutional.
The only one that we haven't put in, I think, is a case called McIsaac.
Okay.
McIsaac from Alberta is an example of a decision where it was ruled unconstitutional.
Yeah, and there's one recently from the Yukon as well. So outside of Ontario, there are decisions where it's ruled unconstitutional. We'll see if it gets up to a higher court at any point. Now, the last point we're going to make is just what if the defense's application is deficient? So obviously, it has to be within 7 days. It has to be served. There has to be evidence of why it's relevant. Those are the procedural criteria that are necessary. Crowns are going to resist if, at that first stage, if the Crown is able to argue that this evidence would never be admissible, it's not capable of being admissible, which is one of the qualifications, the Crown is going to argue that it should be shut down at the first stage, because then the complainant doesn't get access to any of the materials, doesn't get counsel, we don't even get to that second stage hearing. And there is good case law to suggest that if the application is not only administratively deficient, but if substantively that evidence could never be admissible, in other words, it's obvious it only goes to a prohibited myth if it's 276 evidence, then it should be, and the case law would support the fact that it should be shut down at the first stage. And then the last slide is some case law which demonstrates that judges shouldn't embark on needless or meritless evidentiary hearings. We do need judicial efficiency, but I would say, it's certainly what we tell Crowns is if there is substance there, if the evidence could be admissible, even if some of the administrative criteria are not met, the Crown should not resist the application, because ultimately it could be brought at a later point in time, and we want to make sure that fairness to the accused is always going to be honored. So it's really about the merits and the substance. Okay, so we are now done.
It.
That's done for us. Now we're just going to switch spots, and I'm just going to introduce the next speakers.
And I'll say I might have to run out due to childcare obligations. It's not because of anything offensive that they're about to say. Thank you, everyone, for having me.
Okay. Okay, so why don't you guys come down here? Maybe I'll just stand up for a second. And okay, so Sharif Foda, who is to my left, he's a sole practitioner who works almost exclusively in criminal defense. His work focuses on street crime and large, complex guns and gangs prosecutions, but he maintains a general practice and regularly represents people charged with sexual assault. And he's appeared at all levels of court in Canada, and he practices in English, Arabic, and French. Neville Gowalla, who is to his left, is an assistant Crown attorney in Toronto since 2002. He's been in the Toronto office. He's done stints on the child abuse team and the summary conviction appeal court team. He was called also to the bar in Northwest Territories in 2013, and he's practiced in those northern communities. And he's a regular lecturer at the Toronto Police College. Since 2014, he's been the co-director of the Ontario Crown Attorneys Association summer school course, Sexual Violence, and he's also now the Toronto representative at the Regional Sexual Violence Crown, part of the team that I chair, the Sexual Violence Advisory Group. He's the Toronto rep. So they are going to be here to talk about the relevant case law.
Thanks, Jill. So you've heard a little bit about what we do know about the legislation. We're going to talk a little bit more about some of the known unknowns that we're facing a year later, and some of the unresolved issues. So first, let's just talk about the timing of these applications. As you probably know, the rules of court say that other sexual history applications require notice, and that has to be 30 days ahead of time. But Sharif, what's the legislation tell us?
The legislation itself says, and this is under section 278.93 sub 4, and you'll recall, as Jill and Megan told us, that these are the sort of procedural provisions that apply to both section 276 hearings as well as the private record, the new private record adducement regime. Provides for at least 7 days notice or any shorter interval that the judge, provincial court judge, or justice may allow in the interests of justice. So that's the specific wording in the legislation. Although 7 days is provided for, sometimes it may make more sense to bring it in advance, especially if you're going to be as defense counsel, planning your schedule when you're representing a complainant. You might want to advocate for some advance notice because things often blow up, and that can really get complicated when we have now 3 people that we have to worry about in terms of scheduling as opposed to just 2. And there is always the possibility of mid-trial applications. We're going to talk a little bit about that. So that's what we mean in terms of try to plan in advance as much as you can. So, mid-trial applications. What is the possibility of mid-trial applications being brought? This is a decision called RS, sometimes it's indexed as RS or ARS or RS, and then in brackets A, but the neutral citation is 2019 ONCJ 645. There's 2 RS decisions, right? This one that I just gave you the citation for, that was a challenge with respect to the constitutionality of the regime under sections 278.93 and .94. And remember, again, these apply to section 276 applications, as well as applications to adduce private records and records as defined under 278.1. So in the context of this constitutional challenge, again, this decision, by the way, was released in September of 2019. It was a question of statutory interpretation to determine whether or not the application could be brought mid-trial or not. And recall, the language is at least 7 days previously or any shorter interval that the judge, provincial court judge or justice may allow in the interests of justice. So Justice Breen examined the arguments for and against having an application brought before trial or mid-trial. And some of the considerations were, the right against self-incrimination. He also examined, because those arguments were also raised in Duroc in 2000 before the Supreme Court. He looked at the arguments in the context of section 276. He also made the distinction between evidence of other sexual activity and impeachment material, right? These are kind of 2 different questions. Impeachment material will often only, the value of impeachment material will often only crystallize after the examination in chief, whereas other sexual activity, the relevance of other sexual activity is often apparent before the complainant testifies. Impeachment material is often used in the middle of cross-examination, and Justice Breen noted that sometimes the foundation for an impeachment is laid in and of itself during the cross-examination, right? An example is, are you sure you never spoke to the accused after this day, when that point was never raised in examination in chief? So at paragraph 71 and 72, this is where Justice Breen has this discussion. He discusses the possibility of a complainant deviating from a prior statement during cross-examination on reasons for changing evidence. This doesn't solve the problem of when the foundation for the inconsistency is laid in current cross-examination. That's what I was just mentioning. And at paragraph 72, he also talks about practical impediments to questioning about what the complainant learned from access to the application. So for example, if you want to cross-examine a complainant, she has access to the materials, right? Because the section 278.93 and 94 regime give the complainant access to the materials if you have to, if you're applying to adduce private records, right? So then, obviously you lose impeachment value if the complainant and complainant's counsel are aware of the materials that you intend on using. One of the arguments against that in RS that was raised by the Crown was saying, well, you can always cross-examine the complainant and say, well, you learned about this record during the application, this pretrial application under Section 278.94. You learned about this record during that. And the Crown had argued that is an effective way of addressing this issue of kind of reverse disclosure from the defense, that you can just cross-examine your way past it and say, you know, you got all these private records that you knew that we were going to use in trial, and that's why your evidence in chief was like this. But Justice Breen notes that there are impediments to raising that kind of cross-examination because of solicitor-client privilege issues, right? You're not going to be able to say, well, you learned this from your lawyer, or you learned this from your lawyer, unless there's a waiver of solicitor-client privilege. So Justice Breen looked at all of that and ultimately found that interpreting sections 278.93 and 94 as requiring a pretrial application, as opposed to it having the discretion for a mid-trial application, would compromise an accused Section 7 rights. So in order to have sections 278.93 and 94, in order for those provisions to be constitutional, and it's kind of like what the Supreme Court did in that I believe it was in the case of Lavallee, we kind of reinterpret the legislation in a certain manner in order to protect the constitutionality, in order to make sure that it's constitutional. Justice Breen said, we have to be able to interpret this provision so that it provides for mid-trial applications. We have to read this section 278.93 sub 4, where it says at least 7 days previously or any shorter interval that the judge, provincial court judge, or justice may allow in the interest of justice. We have to read that as allowing for the possibility of a post-examination in chief, pre-cross-examination application in order for it to be constitutional. To do otherwise would then engage and probably violate an accused Section 7 rights. I would personally note that this interpretation actually is the most coherent one when you look at the actual language, the actual provision, because we're engaged in a question of statutory interpretation. It's clear as day, any shorter interval that the judge may allow in the interests of justice. And again, the paragraphs that you're looking at are 71, 72, and he ultimately concludes, Justice Breen says that I conclude that the statutory provision that compels disclosure of impeachment material to a complainant in advance of cross-examination compromises the fairness of a trial contrary to Section 7 of the Charter. Then there's the decision of certiorari that I believe Neville's going to talk about.
Yeah, so just on that point about Justice Breen's comment, when you want to frame your argument, if you're going to take the risk of bringing a mid-trial application, you want to frame it in that language of in the interests of justice. So I don't entirely agree with what Sharif is saying about it, but certainly Justice Breen thinks you can bring these things in a mid-trial application. But my suggestion is you're going to have to get over the hurdle saying it is in the interests of justice, so you want to frame your argument accordingly. Now, feel a little bit silly talking about certiorari here when the counsel who are on it are sitting before you, so certainly you can throw questions their way. But this is a decision of Justice Horkins. It came out 5 weeks after ARS, and Justice Horkins, for those of you who don't know, presided over the Ghomeshi trial, of course, which had the emails that were put to the victims or the complainants in that trial. So this comes out October 25th. We're here to talk about the timing issue, but there is some interesting language there for counsel for complainants about things that can be done in anticipation of a mid-trial application where things like seeking the court order for funding, essentially making room in your schedule, being on standby is there, and perhaps touching base with your client a little bit about what might be anticipated as coming down the pipe all helps sort of in the efficiency of the administration of justice if you do have one of these mid-trial applications. To my mind, and you can look at certiorari, Justice Horkins, really he follows Justice Breen for the most part, and he does also identify, look, I think the fair trial rights are implicated if you have to bring the 7-day notice application. To my mind here, what we're seeing in a lot of the cases at this point is applications by counsel for directions, being brought by the defense. Arguably very wise. At the very least, you're not going to alienate or irritate your jurist by bringing a mid-trial application when they're thinking, hey, this is, I thought this was happening 7 days ahead of time. And perhaps more importantly, you're not going to get the door slammed shut with a denial for you to be able to bring the application because the judge finds it's not in the interests of justice. So a lot of the cases that we're going to talk about and a lot of the litigation happening right now comes in the context of applications for direction, so that everyone's on notice that this may or may not come, and then you can deal with the arguments of admissibility and the mid-trial application versus not as well. In the case for Horkins's case, really the question he first dealt with was, are these records? There were two sets of records, pre the date of the offense and then for June 16th, which was the date of the offense. He makes some findings there. He says they're presumptively inadmissible, the pre-June 16 ones, so you have to bring the application, so you're on notice there. And then the June 16th ones, he assumes without concluding that they're not subject to the 276, but they do appear to be private records, so they're not past sexual history, but they may still have a reasonable expectation of privacy required. And so, again, the direction from the bench is you're probably going to have to bring an application. And again, so when you have that direction, the advantage that everybody has is you can get ready for the potential for a mid-trial application. So you've got some skeletal materials together, and the parties are ready to go without a huge interruption to the process. So in terms of, so that's handy. In terms of the timing issue, as I say, he follows ARS. He says, defense, ultimately, you get to choose when you bring the application, when you think the reason for the application is crystallized in the evidence. He does cite, and we're going to talk next about a case called MS by Justice Chapman, which really is the opposing decision here. So he cites the case, but he doesn't refer to it at all in the issue of the timing, except at paragraph 31. He does refer to quote-unquote logical issues that come up, and as I said earlier, he says that's really quite secondary to an accused fair trial rights, so those will prevail here. So again, the practical point from all of this is the application for directions puts everyone on notice that this may be coming, and then it gives all counsel the opportunity to essentially get everything they need to get together, at least at a preliminary stage, so that once the trial gets rolling, you can roll through this application quite efficiently if possible. So what about MS, Sharif?
So MS, and this is just in the MS is a case that kind of discusses a lot of things, but right now we're talking about the timing of the application. So this is a decision by Justice Chapman of the Ontario Court of Justice. It was released after RS but before ectiari. MS's discussion of the discussion of the timing of the application wasn't discussed in ectiari although other aspects of the section 278.1 regime in MS is, and we'll get to that later. Justice Chapman discusses the timing of the application under sections 278.93 and 94 in MS, and directed ultimately that the application be brought 7 days in advance of the trial. It's fair to say, I think, that MS is much more complainant-centered than it is on the accused charter rights. It gives the following reasons for why the application ought to be brought in advance of the trial. One of the main reasons is so complainants can make an informed decision as to whether or not they want to take part in a trial. So, in other words, if a section 278.93 or 94 application is being brought with respect to private records, again, these records are records that contain personal information of the complainant over which she or he maintains a reasonable expectation of privacy. If an application like that is being brought, let's say communications, emails, or whatever, and the complainant has access to them, I'll use the term she may decide that she does not want to participate in the trial, and so Justice Chapman says having the complainant be served with these materials or have the right to sort of participate in this question before she testifies in chief might make more sense. Although Justice Chapman does recognize that, it's the complainant does not decide whether or not the prosecution goes forward. She says the reality of the historic disadvantage women and children have faced in seeking justice cannot be ignored, and indeed further perpetrated through an evisceration of what the obvious intent of Parliament was, namely that as much as possible evidence of other sexual activity be vetted prior to the trial. I would just note one thing about this decision. This is a decision where essentially a motion for directions was being brought by defense counsel. And the motion for directions was over material that defense counsel had in their possession from the accused. This material consisted of social media posts, Instagram posts, WhatsApp messages, I believe, maybe Facebook messages, and photos and videos. These materials were provided to the court, but not to the Crown. And so it was one of these cases similar to WM that we'll talk about a little bit later, where the threshold question was, is there a reasonable expectation of privacy in these records? Because if there's no reasonable expectation of privacy, then no section 278.93 or 94 process has to be followed. What is somewhat unique about MS is that these records also clearly engaged section 276. Okay? So remember, both 276 and private record applications need to follow the procedure under section 278.93 and 94. Where the records in question, whether or not, and the question of whether or not they have they contain a reasonable expectation of privacy is undecided. But where those records do not engage section 276, then I say the question is a little bit different than what we have in MS, because those considerations of whether or not the complainant ought to see these materials before the application is adjudicated is different where we're talking about other sexual activity than when we're just talking about, for example, text messages that may or may not implicate the dignity or private nature of the complainant's life. All of this to say is MS is a case where we're clearly talking about a section 276 application as well, because those photos and videos and social media posts clearly implicated other sexual activity. So one of the arguments that Justice Chapman made was we need complainants to be able to make an informed decision as to whether or not they want to participate in the process. Another reason Justice Chapman provides is that mid-trial applications could, quote unquote, bifurcate the evidence of the complainant. Let's say the complainant testifies in examination in chief, a mid-trial application is brought, and then she would have to be cross-examined later. Justice Chapman calls this unmanageable and not at all what Parliament intended. I think that's, I don't agree with that conclusion at all, because Parliament clearly intended for some shorter interval being provided for in the language of section 278.93 sub 4. And the reality of criminal litigation, frankly, post-Stinchcombe, is that there are often mid-trial interruptions or bifurcations, especially when it comes to new disclosure. The rule in Brown and Dunn often requires recalling a witness, and bifurcation of a complainant's testimony, in my view, is not inherently problematic or offensive, whereas preventing an accused having the full impact of impeachment material is a substantial disadvantage. Justice Chapman also rejects the argument that the 7-day notice requirement, being shorter than the traditional 30-day requirement, has any importance. So Justice Chapman ultimately decides that this application has to be brought in advance of the trial. She disagrees with Justice Breen's decision in RS, directs that it be brought in advance of the trial. I want to make a couple more points. One, remember, the rules of court provide for 30 days. 30 days unless you are dispensed from bringing it. So the fact that the criminal code provides for at least 7 days in advance, you still have to, if you intend on bringing a section 276 application, don't rely on the criminal code. Remember the rules of court. They are more onerous. You have to bring it in advance, 30 days in advance. The other thing that you really have to pay attention to is, remember, is the 278.93 or 94 application that's being brought, does it relate to only other sexual activity? And if it does not, then the next question is, okay, we're talking about records. Could these records potentially trigger the application of section 276? Because otherwise, if it is just if we're just talking about text messages that are non-sexual in nature, then it's a very different question and a different analysis that we're talking about. I will turn the floor to Neville to talk a little bit more about this.
So as you deal with this debate and the personal question when you're practicing of do I bring this mid-trial or not, you really do want to look at MS versus ARS and the dialogue that happens there. I'll just point out that one of the things, and I thought it was pretty persuasive, that Justice Chapman points out at paragraph 77 is Bill C-51, there's no change in the notice provisions, and it's the same provisions that were upheld as constitutional in Darragh some 20, 30 years ago. So there's a pretty persuasive argument that there's going to be no constitutional problem, and the Supreme Court is going to say, hey, we have no problem with enforcing these. She also points out at paragraph 81 that these cases typically happen between people who know each other. The stranger sex assault is more the rare dynamic. And she feels that it defeats the spirit and the intent of the legislation and causes a lot of what she calls significant case management mischief. And she repeats this again later in the decision. And, we're now in a practical, we've got to deal with 2016, Jordan, all of that reality. And if any of you have ever done a jury trial where the judge has to keep the jury waiting in the middle of a trial for an application, it doesn't go over very well. So I don't fully agree with the idea that, it's no big deal to have someone testify, send them home for a couple of days, and then have them come back. That is a big deal, and that is a big imposition on people's lives, and Parliament, in my view, sought to cure that as best as they could. And so we find ourselves in this situation. So you should be prepared to deal with all of those challenges if you are sort of finding yourself in a mid-trial application and trying to justify the need for it. She also points out that truth-seeking is part of the whole reason we're here, and that's all enhanced by the victim's participation in the hearing. And again, repeatedly, she points out that in Darrow, the court had said you have no right to ambush a complainant. That's not a fair trial right. So just keep all those things in mind. Yeah.
I just want to make a quick point. Many of you who are in this room or who are on the webcast are considering these issues from the context of victims' counsel or complainants' counsel. And so for you, because there are these decisions that do justify mid-trial applications or motions for directions, it's a significant impact on how you are going to conduct your business with your client. Because sometimes if you have a mid-trial application that seems to be allowed, where do you fit in? Is this going to be something that's going to be done throughout the trial, where you're just going to have like a half a day to deal with this application and you're going to have to get up to speed really quickly, or is it going to involve an adjournment of the case so that you can get on board? And so it's going to depend on the case, but I know in Ectiari, when Megan and I had that case, we did contemplate a mid-trial application, and we had victims' counsel, complainants' counsel actually in the wings on standby. And as soon as the hearing would have been ordered, it wasn't because the case didn't proceed for other reasons, but if a hearing would have been ordered, complainants counsel would have been ready to go, and she sort of had allocated a day to deal with those matters. So I just wanted to throw that out just from the perspective of complainants counsel.
Thank you. So just we're going to move on just for the sake of time. At the end of the day, the unresolved issue is, what do you have to do? 7 days, 30 days, mid-trial, that's all live and well. There's a split in the case law. There's nothing binding. This should all get sorted out, I'm sure, in a couple of years when it goes up to the Court of Appeal and beyond. But at this stage, best practice, motion for directions, or at the very least, bring it up in the JPT, or I would say you can expect it's going to start getting raised, if not by the Crown, then by the judge at the JPT, so they can have some sense of where this is going. Do we need to book extra time? That kind of thing.
I would just also refer you, there's one decision, Justice Dawes' decision in XC, 2020 ONSC 410. There's also a discussion of the timing, whether it can be brought mid-trial or if it has to be brought pre-trial. 2020 ONSC 410.
Okay.
It's in the PowerPoint.
Is it? Okay.
Slide
Oh, yes,
30.
yes, it's on this slide.
Okay, so we're going to burn through our time, so we're going to skip ahead here. So next slide.
Yep.
Oh, you were on there. Okay. Reasonable expectation of privacy in communications between a complainant and the accused. So there's a list of cases there for you to digest. We'll just briefly go through those. HAR Superior Court decision. It was audio recordings. The conversations were recorded. There was a relationship of trust. It was a foster father to the complainant. The conversations took place in the home, so there's an environment of privacy there. And the court ultimately declined to decide the issue on the motion for directions, and they decided to proceed with a full-blown 278-9394 hearing. And importantly, the court looks to Jarvis 2019 voyeurism case from the Supreme Court of Canada, where reasonable expectation of privacy is discussed quite a bit, and so you should be looking there as well as you try to frame your arguments. And one of the things the court says is that there's a contextual analysis that is required to determine if it is a record, and you're going to hear that language contextual come up again. WM, again a Superior Court decision, their Facebook messages that did not involve sexual activity. The finding was there was no reasonable expectation of privacy, and that included the factors considered was the content, how were they sent, what was the nature of the relationship between the parties, and what are the policy implications involved here. That's Justice Davies' decision, and you can see how she tackles each of those issues in more detail if you look at the case. In my Superior Court decision, their WhatsApp messages were there. Again, no reasonable expectation of privacy was found, partially because there was a third party involved in the conversation that was going on. And the court also talked about the nature of the relationship. The context here, the reasonable expectation of privacy discussion related around the complainant's drug use. But she had talked about her drug use with the accused when they were really closer to being strangers. They had just barely become acquainted. So you think about that context. Are you talking to strangers? Are you talking to friends? Or are you talking to an intimate partner? All of that context informs the analysis that the courts are looking at. MS, similarly, Court of Justice decision. Lots of stuff there. Facebook videos, photos, Instagram, WhatsApp, and Snapchat messaging. There, a reasonable expectation of privacy was found over, as many of the messages had sexual content. Keep in mind, reasonable expectation of privacy has both subjective and objective components, and privacy can be both inferred and explicit. We're going to run out of time, so I'll just say there are decisions out of Ontario that are not taking this contextual approach. In Ontario, it's mostly contextual. Some decisions take a categorical approach, and you can look at the citations with regards to that. So Sharif, tell us about the contextual approach a little bit more.
Sure, and I don't know if we've made this clear yet. We probably have, but it bears repeating again. Why are we looking at whether or not there's a reasonable expectation of privacy in these records? If there is no reasonable expectation of privacy, then you don't have to bring an application under section 278.93 and 278.94. In other words, if there's text messages between the accused and the complainant that are in the possession of the accused, and the accused does not want to share them with the complainant, which is what would occur if you have to bring the application, then you can bring a motion for directions. Share the records with the court, not with the Crown, and we want this threshold determination. Is there an REP or not? If there's no REP, that's it, hold on to it, and you can use it for impeachment. If there is a reasonable expectation of privacy, then you have to proceed with the 278.93 and 94 motion. So that's what a lot of these prior cases are talking about. Some of them are, in effect, motions for directions to determine whether or not you have to proceed with the regime. What do the courts look at? Like Neville said, in Ontario so far, we're seeing a lot of contextual interpretation of this determination on this threshold question of whether or not a 278.93 or 94 application has to be brought. So what is the connection or the relevance to the allegations? What is the manner or the platform in which the messages were created or obtained? In terms of the relevance, I would note this. There's not much discussion in the case law on relevance of the communications, I think because relevance is usually apparent on first blush, and in any event, under any application under section 278.93 has to identify, remember, with particularity, the relevance of the evidence to the issue at trial. I think usually defense counsel will only bring a motion if the messages are relevant. If upon receipt of an application you're representing a complainant, the relevance of the messages isn't apparent, you can always speak to your client, try to learn more, and bring that up if you're representing a complainant. The relevance has to be made clear. In terms of the manner or platform in which the messages are created or obtained, you could think of things like, was it surreptitiously recorded, or was it known to the complainant that you'd have the messages? And a very real-world example for example, are these WhatsApp messages, or are they Snapchat messages that are deleted, right? You could think of Snapchat messages perhaps engaging a reasonable expectation of privacy more so than WhatsApp messages. Are other parties privy to the conversation? So does waiver of privacy, is that a factor that kind of plays in? Were some of the messages shared with the police? That's a factor that was considered in the decision of XC. If they are shared with the police, then potentially a waiver of privacy. You have to also look at the relationship of the accused and the complainant at the time. What time do you look at? You look at the time the application is brought, not at the time the records were created. And that's something that Justice Davis and Justice Roberts in the decision of Mai, I believe, discuss because of the language of the provision. It's a record in which the complainant has a reasonable expectation of privacy, not has or has ever had or had in the past. The idea of risk analysis that the Supreme Court seems to be moving away from in the Section 8 context still seems to be at play here. Justice Davis in WM says, I know the Supreme Court has been moving away from risk and control when we're talking about Section 8. Nevertheless, it's relevant to here. And the policy implications, what are the policy implications? That a reasonable expectation of privacy would trigger the complainant getting the messages. And so that's something to consider, that the fact that as a matter of policy, it would eliminate the impeachment value of these messages. We only have 1 minute left.
And I just have to make one quick point, I'm sorry.
Yep.
And it's just to bring it back that everything that's being talked about here is the question for defense counsel. If you're representing an accused, do you have to bring a motion for directions? And the question for the court, is there a reasonable expectation of privacy? As complainant's counsel, you don't get involved generally until a decision is made that there is a reasonable expectation of privacy and an application has to be brought. So generally speaking, complainant's counsel does not have standing at the stage where there's a motion for directions determining that. In exceptional cases, if a court decides they do need the participation of complainant's counsel, they on their own motion will make that order. But generally speaking, the complainant doesn't get involved in that stage. So I just wanted to clear that.
Practical advice, I know we're quickly running out of time. If you're representing a complainant, always ask the complainant, what messages are there? What impeachment material could the accused have in his or her possession, just to be alive to this issue? And you may or may not, on a motion for directions, be served with materials. Sometimes defense counsel may do that. You may want to seek intervention as well. Very quickly, next point, what application materials does the complainant have a right to? Most of the time, the complainant gets everything. That's what we're seeing in the case law. There are a couple of cases where it's somewhat limited. These are in RS, and this RSA, this is another decision by Justice Breen in the same case. It's a different citation because it's a different decision in the same case. Justice Breen limited the access to those materials, limited the access by saying, counsel for the complainant, don't share everything with the witness. We don't want to interfere with the truth-seeking function of the court. Although generally it does seem, for practical reasons, we give the complainant all of the materials. I'm going to move on quickly because we're running out of time. When should complainant get access to materials? If you're scheduling this in advance, in my experience, what I see is normally they say just serve the complainant with the materials prior to stage 1. You're only supposed to get them at stage 2, but often the stage 1 arguments and analysis and decision are made very quickly in court, and it would be difficult, practically speaking, for counsel to the complainant after the stage 1 determination, getting to speed on everything, getting instructions. I think that has the risk of bifurcating the proceedings a lot more. There are decisions, TPS, the decision of the Nova Scotia Superior Court, where we just say, as a practical matter, give it to the complainant in advance of stage 1, even though there's no standing at that stage. You can expect, I think, as a practical matter, because of appointment and funding purposes, that you likely, as a complainant or counsel for the complainant, are going to get the materials prior to stage 1, although you're technically not entitled to it.
Yeah, you may not get them until stage 2. It depends. Anyway, I want to thank Neville and Sharif for their excellent work in trying to digest some of the case law. And we're just going to have a brief, everyone stay put, but I think somebody has to come up here and change the PowerPoint.
All
PowerPoint, I'm going to invite up Caitlin Casper for the next presentation, and I'll just do a brief introduction. Caitlin is an Anishinaabe woman from the Chippewas of Georgina Island First Nation. She holds an honors specialist in political science from the University of Toronto and a Juris Doctor from Osgoode Hall. She practiced in Northern Ontario in Kenora before opening her own law practice, specializing in criminal, family, child protection, and mental health law for communities in the North and especially in fly-in First Nations reserves. In 2014, she joined Aboriginal Legal Services as legal counsel, and she has since represented clients at every level of court within the country, including the Supreme Court, always advocating for the recognition of First Nations, Métis, and Inuit perspectives and representation on issues that most impact Indigenous people in Canadian law. So if I could have Caitlin Casper come on up.
Good morning, everyone. This is, as you can probably appreciate, is going to be a presentation that is going to take into account both of the historical context of Indigenous people and especially the experiences of Indigenous women. My articling student, Desiree Duplessis, is phenomenal. She has created this magnificent PowerPoint. I feel like this point in her articling term, if I stare at a screen blankly for long enough, she comes along and saves me, and we have this as a result. So she's going to try her best to keep me on track and on time, and just be patient with that. So what we're going to do is we're going to talk about the historical context in terms of violence against Indigenous women. We're going to talk about discrimination through myths and stereotypes, the current realities of how that violence looks today. We're going to try and unpack a little bit the understanding, power, privilege, and unconscious bias that occurs, especially in the criminal justice system. And then we're going to talk about how you can best represent Indigenous women clients, in particular ideas around cultural safety, and then best practices in terms of mitigating those injustices. So in terms of the historical context, we know, and many of you are very aware already, that Indigenous women in Canada frequently experience challenges and discrimination that are not necessarily shared by other non-Indigenous women and not by Indigenous men either. Indigenous women have often been described as shouldering a double burden, where they are not only women with all the obstacles that come as a result of their gender, but also being Indigenous as well, with all of that colonial context. So it's important that we understand what this relationship is with our communities and how it's been affected so drastically as a result of colonialism. So we have here this wonderful quote from Beverly Jacobs, where she talks about the fact that women were respected traditionally for their spiritual and mental strength, and men were respected for spiritual and physical strength. Women were given the responsibility of bearing children and the strength and power to carry that responsibility through. Men always respected that spiritual and mental strength, and women, in return, respected the men's physical strength. There was always a balance, and that's what's most important, between men and women, because each of them had responsibilities that were equal to each other's, and neither one had power over the other. So in many First Nations in Canada and across Turtle Island, North America, First Nations often could be described as either matriarchal or matrilineal, which means that family name and identification through clan system often passed through the mother. Women held powerful roles in governance and resource management and were respected, obviously, for their life-giving capabilities. An example of this is women who would come together and choose who was going to lead the community, who was going to become chief. And so that concept of balance and traditional strengths held through all the way until colonialism. despite many First Nations different beliefs and the different social systems and values they had, it doesn't change the fact that we all share a common colonial history, and definitely that Indigenous women's power, status, and material circumstances changed drastically after colonialism occurred. So this is our historical timeline. These PowerPoint presentations, I understand, will be made available. I'm not going to go over every single part of our historical timeline. I offer this to you because for future reference, I find it's very helpful in terms of understanding what's happened and when, and especially in terms of understanding how so much of the reparation that Canada is trying to do has not occurred until the last few decades. So this really is challenges that we've experienced generation after generation. So you can see in the timeline that the relationship between Indigenous people and Canada changed drastically after 1867. Before that, often any type of contact or any type of agreements were made on a very nation-to-nation basis, and it wasn't until the kind of Dominion of Canada formed that the government decided it would be in their best interests to start signing real treaties, and that's when our numbered treaties that span the majority of Canada's landmass now were signed. When those treaties were signed, we know that it created reserve land. First Nations people were pulled from their traditional migratory patterns. They were put into small reserves that were set aside for them, and an Indian agent was appointed by the Canadian government to make sure that all the rules of the Indian Act were followed. It's important to understand that the treaties that were signed between Indigenous people and Canada is not the Indian Act, and that the Indian Act is a very distinct and separate piece of legislation that was not signed into law until after the majority of those treaties had already been signed. So the Indian Act was meant to govern and basically regulate and control how Indians acted on their reserve land, and was meant to regulate all the economy of those reserves, the social structures, and the politics. It was designed with a very colonial, patriarchal perspective, where women were regarded as dependents and their control rested on however the head of the household deemed appropriate, and that was obviously men and the Indian agent. So the influence that Indigenous women had in their communities changed very drastically, very quickly. And so the next two slides are just for future reference in terms of notable dates in the history of Canada's relationship. They're fairly self-explanatory in terms of the continuous and ongoing policies of assimilation. You'll notice that I've put on there the residential school system, the child welfare scoops, and it's incredibly important to understand the dynamics and the history behind them, because they really do have such an impact on Indigenous women and how you will be able to understand and relate to them as clients. Obviously, if you've not had the chance to read the Missing and Murdered Indigenous Women and Girls Inquiry Report that was published in 2019, I would encourage you, please, before you work with any Indigenous women, to even read the summary of that. It's very important that you understand the realities of what these women are facing today. So in terms of discrimination through myths and stereotypes, the European religious beliefs, as we know, very much held precious this idea that a woman should be chaste and that they should be virtuous. There was, and still is, a very mythical archetype of the virtuous Indian princess who is willing to reject her traditional ways. We think about Pocahontas, we think about Peter Pan, this whole idea of this beautiful, exotic Indigenous person. We also see how we have on the opposite side of that spectrum the Indigenous woman who is defined by hardship, who has been downtrodden her whole life, who is addicted to alcohol or substances, who's working in sex work, who's described as a prostitute, those types of things. And so you can see that there is this binary that Indigenous women are constantly faced with and that they're operating within. And this type of discrimination and this idea of morality for an Indigenous woman was written right into the Indian Act. I'm not sure how many of you are aware of the history of the Indian Act, but I can tell you that there were provisions regarding immorality on reserves where the chief complaints centered on a woman's sexual misbehavior. So this idea of becoming the promiscuity police for an Indian agent happened, right from the creation of the Indian Act in 1867 and right up through until it was changed in the 1950s. You should all be aware the Indian Act is still in existence. We are still dealing with severe gender inequities within it. And there are a lot of Indigenous people who are holding dear to that because they've been defined by it for so long, but then also people who want it abolished and locked away as like a part of history that we can start to heal from. But obviously we can't start that process until it's gone. So outside of this idea of immorality on reserves, there's three major areas of gender discrimination as a result of the Indian Act in history that it's important for us to understand. These are control over the family unit, the forced dislocation from reserve communities, and political exclusion. Each one of these areas I'm going to go over very briefly because it's incredibly important that you understand the positions of vulnerability and marginalization that have been so detrimental to Indigenous women's safety and for stability in their lives. So in terms of the control of the family unit, the Indian Act, you may be aware, determines who is status and non-status. There is a registry based in Ottawa that has the names and the numbers of all people who are deemed Indian status in Canada. The government traditionally in the Indian Act provisions decided that to be an Indian, one had to either be an Indian male, married to an Indian male, or the child of one. If a status Indian woman married a non-Indian, she would cease to be Indian. I don't know how that happened, but the government legislated it so. She would lose her status. And with it, she would also lose all of her treaty benefits, all of her health benefits, the right to live in her reserve community, and even the right to be buried on the reserve with her ancestors. If an Indian woman married another man from another reserve, she would cease to be a member of her own band on her own reserve, and she would become automatically a member of his. So under this system, a woman's life absolutely depended on males, and it, as you can imagine, completely disrupted the systems that had been in place for hundreds and hundreds of years prior to contact. The result of this idea of Indian status also resulted in the forced dislocation of many Indigenous women. The creation of the reserve system and who could reside in them impacted women drastically. There were many ways that Indigenous women could be forced to leave her community, which left them obviously in very precarious positions. For example, obviously we've talked about if an Indian woman married another person from a different community, she would have to leave and raise her children in the other community, work to establish connections and social supports there. If he died or decided that he didn't want to be in that marriage anymore, then she was forced to leave that community, but she couldn't go back to her own. So as you can understand, this period of time was where huge numbers of Indigenous women migrated from reserve communities and moved to urban centers. In urban centers, as we know, If you're coming from communities where your family lives, where everyone you know lives, these women were forced into positions where there was no social supports, no community structures that they could relate to, no community ties, and the impact and consequences of this often put Indigenous women and families into situations that, as we know, includes violence and state interference through child welfare, especially for young families. In terms of political exclusion, as I've mentioned, Indian Act replaced all of the traditional forms of government, and obviously, if we did not have status as human beings, we also did not have status in terms of the ability to vote or to make change within our communities, and that did not change until the 1950s as well. So in terms of the idea of the residential school system, of the 60s scoop, and of the millennial scoop, while women were dealing with all the implications of the provisions of the Indian Act that determined who they were, where they lived, and how they dealt with their own communities, at the same time, Canada was ongoing complete assault on the cultural aspects of Indigenous communities, and we have all of the horrors that came out of the residential school system, the 60 scoop and the millennium scoop, which women were concurrently going through as well. So I'm not going to talk too much about these different points in Canadian history. Suffice it to say that we know that the residential school lasted for over 160 years. Many of the leaders, teachers, parents, and grandparents that live today went through that period of time. The intergenerational effect is still being felt by all those descendants of those who were part of that system. And I think for the purposes here, what's important to note is that these personal traumas transmitted and compromised family systems generation after generation. There was a loss of language, loss of culture, loss of traditions and the teaching of traditions, and a sense of worthlessness was instilled in many students by the people who ran those schools. Self-abuse is very prevalent and takes form in terms of alcohol, substance abuse, and suicide. According to the Manitoba Justice Institute, is the residential school system that laid the foundation for the epidemic we see today of violence against Indigenous women. The 60 scoop, which lasted from the early 1950s until the early 1980s, was the large-scale removal of Indigenous children from their homes. The process, many of you may not be aware of this, the process actually began in the early 1950s when amendments to the Indian Act gave the provinces jurisdiction to go into reserve communities and apprehend children. As you can appreciate, after nearly a century of living under the Indian Act and all the devastation caused by it, many Indigenous communities and still today struggle with poverty, high death rates, and socioeconomic barriers. Instead of trying to fix those issues and instead of trying to provide resources to deal with them, the provincial child welfare agencies instead decided to take the children out of the communities and adopt them into non-Indigenous homes. So we know that we've lost thousands of Indigenous children to the 60 scoop, and that today they struggle with a sense of lack of cultural identity, low self-esteem, feelings of shame, and loneliness and confusion. We're aware that many of those adoptees experience sexual, physical, and other abuse, and that many of those adoptions broke down once the child reached the adolescent age, which I'm sure we can appreciate. They were then left without the support of their adoptive family, as well as with no support from the families and communities that they were taken out of. The millennial scoop is what's occurring right now. Instead of Indigenous children being placed for adoption, however, they are being placed in foster and group homes. Currently, 52% of children in foster care in this country are Indigenous, but they only account for just over 7% of the child population in general. So those are what lead us to the current realities of today's trends in violence against Indigenous women. I think Barton summarized it well when the Supreme Court talked about the fact that there are a number of troubling stereotypes, and this is in paragraph 201 of the Barton decision, that there are a number of troubling stereotypical assumptions about Indigenous women, especially those who perform sex work, including that these people are not entitled to the same protections the criminal justice system promises other Canadians, are not deserving of respect, humanity, or dignity, that they are sexual objects for male gratification, that they need not give consent to sexual activity and are available for the taking, that they assume the risk of any harm that befalls them because they engage in these dangerous forms of work, and that they're less credible than other people. So many people would argue that at this point, violence against Indigenous women has become normalized, with decreased consequences for those who perpetuate these acts of violence. We know that Indigenous women are 3 times more likely than non-Indigenous women to be survivors of sexual assault, and that we experience sexual assaults that are more serious in terms of physical injury and other health-related consequences. Indigenous survivors of a sexual assault tend to be younger. They tend to be more likely to be living in an institutional setting and to report government or community services as sources of social support. And that obviously goes hand in hand with the number that are involved in the child welfare system. It is estimated now that in terms of missing women, that it now totals over 4,000 in Canada. So, how do we move on to understand this idea of power, privilege, and unconscious bias? Well, it goes without saying, power, privilege, and colonialism are part and parcel of the same social construct. That it's through the process of colonization that we exert dominance and control over Indigenous people through either force, through treaties, or becoming the population majority. Colonialism continues in terms of governmental policies still in place, such as the Indian Act, and through other institutions such as the criminal justice system, such as schools that don't teach all of history, especially as it relates to what Indigenous people have gone through. And it's important to recognize that this oppression is so ingrained in terms of the systems that all of you will encounter every day when you walk into court. So it's structural and systemic. A bias is an inflexible positive or negative, often unconscious belief about a particular group of people. Biases result from stereotyping, and with Indigenous people in particular, people overwhelmingly rely on stereotypes when everything that they've been taught for the most part about these communities and cultures is wrong. So every time you as lawyers walk into a criminal courtroom, let it be known that you are walking into stereotypes. You're walking into a situation with your client where the worst part is that sometimes the people who think that they know the most and they are the ones that hold the most power are the ones that know the least. The core challenge is that it's always been accepted to view Indigenous people in this way. And we come from a society that's given itself permission to even define who we are as people. So it's important as an advocate for an Indigenous survivor of sexual assault that you prepare for this reality and that your representation challenges those stereotypes from the very beginning, from the first time you meet your client all the way through until your representation of them is over and complete. So we have here just a few rights of the client. Aboriginal Legal Services has an excellent publication titled Communicating with Your Indigenous Client. It's available for download. And if you want a hard copy, you can call our office, and Jonathan Rudin is more than happy to send them out. But it talks about, and I'll go over a little bit of these issues, what it looks like and what it should look like when you're going through those processes of working with your client. So in terms of interviewing, it's incredibly important that you explain, first of all, what the charge of sexual assault is and what their options are in the plainest language possible. It takes many lawyers years to even understand how to defend or prosecute a sexual assault charge. There are many moving mechanics to this type of complicated charge, and you certainly cannot expect that your client will know what they are. Make sure that you explain what your role is, especially as one of these advocates for victims who may be able to take part in these hearings. Explain how you're supposed to assist them and what can be expected of them during this process. Make sure that you slow down and you ask and you pause in terms of making sure that once you've delivered a piece of information, that it's been understood, and you give that opportunity to ask questions afterwards. Be aware that many of your clients, especially if they've been involved with the system before, may not immediately trust you. It's common among clients that come into our office that they often feel like their side of the story is not heard. And we know, or we can speculate, that this is because, first of all, many Indigenous people, especially women who are survivors of traumatic experience, are very reluctant to volunteer information. This comes from not only distrust of the criminal justice system as a whole, but also it probably includes you as their lawyer. Don't take offense to that. Work with it. Second, it may come from the assumption, because of past experiences of them being Indigenous, that they're not going to be believed anyways. And that takes us back to that whole idea of Barton and credibility. Another thing that's really important for you to address as a person's advocate is their health. It's a sensitive matter, and you shouldn't just come out and say, are you addicted to alcohol or substances? That is not the appropriate way that you want to be addressing a sensitive question like that. I would suggest that you start by just broaching the subject carefully, ask about their family history of those types of things, ask about history of alcohol or substance use, FASD, fetal alcohol spectrum disorder is another good thing to ask about. Things like diabetes, which a lot of Indigenous people struggle with low blood sugar. It's also important to know about all those things because it's going to affect your client's behavior and their ability to be present, especially if you're in a courtroom situation where you're not allowed food and water, and where they may need breaks in order to eat, in order to feel better so that they can fully be present with what's happening. And if you know that ahead of time, it allows you to be better able to anticipate it. If you know that your client struggles with alcohol or substance use, it may be that you need to develop certain methods of communication or times of the day when you can obtain the clearest instruction. These are important things to know because you want to be able to have your client understand and to obtain instruction from them. And if you know that they're not going to be in a good state of mind by 5 o'clock or 6 o'clock in the afternoon, you may want to make sure that those client meetings are set for first thing in the AM. It's incredibly important to listen. I think that a lot of people, especially lawyers, like to think they're good at listening. The reality is that they're not. We have a tendency to talk over people and to believe that we already know what's right. And it's important that you make sure that you're listening to your client and that you're respecting their cultural, their history, and their own individual experiences. So in terms of language differences, everyone here speaks English. For most people speak standard English, and that's the version of English that we think we don't have an accent. In Canada, Indigenous people, particularly those living outside of urban areas, speak varieties of English that sound accented to us. There are many prejudices that result from this accent. It's called linguistic prejudice, And we've seen all too often Indigenous people who report being locked up for being drunk because of police mistaking pronunciation differences for slurred speech. We know that elders have been denied medical care as a result of it, and that children have been overdiagnosed with speech problems, and all of these are just examples of how linguistic prejudice can occur on a day-to-day basis. So this type of accent is sometimes called Aboriginal English. Among First Nations people, it's called a res accent. And the varieties share many features, but all have different pronunciations, slightly different grammar, and most importantly, there are different discourse behaviors. And it's important to understand this idea of a discourse behavior because how we say things often carries as much meaning as the words we use. So thinking about two speakers belonging to the same speech community, when we have a conversation, we can read each other's intonation. We know how much or how little of a pause and what those things mean. We understand our gestures and facial expressions. And this is how messages immediately get understood and how they go from one person to another. However, if you're in a situation with somebody who won't make eye contact, someone who takes a long time before they answer you, your assessment, or many people's assessment, would be that they are being deceptive or that they're hiding something. It's very easy to misinterpret communicative intent for Indigenous people. The more common features of what you need to know about Aboriginal English is that there's a higher tolerance for long pauses between speakers' turns. In many of our communities, leaving a longer pause is considered polite. It's considered leaving enough of a gap to ensure that I'm done and that the next person can begin. Eye contact, too much eye contact is considered to be, at the very least, awkward, and in the worst cases, it's just downright rude. It's especially rude when you're talking about confrontation with authority figures. And asking the obvious or the same thing repeatedly also does not occur very often in discourses between Indigenous people. Repeating oneself is not something that your client, who, if they do speak Aboriginal English, it's not something that they're necessarily going to be accustomed to. And so that also goes hand in hand with how much or how little is said in response to a question. It's common for a lot of people who speak Aboriginal English to say less in response to questions posed, especially if they're not in a close relationship with that person. And so as a lawyer, where you're trying to obtain information from your client about what happened, it's very much a struggle. It can be a struggle. And so you need to be prepared to spend longer with your client than probably what you're traditionally used to. It's important for you to tell your client why you're asking them the same question repeatedly and let them know why you need the minutest of details. And also you want to prepare the client in terms of what it's going to look like when they're on the stand and they're actually in court. We're not suggesting that you urge your client to change their behavior or their speech, but it is important for you to tell them that small gestures, like the occasional eye contact, will help them when it's time for them to take the stand. Suggest that eye contact with the judge or jury might help in terms of how non-Indigenous people see credibility. It's helpful to try and remind them to speak louder, and then working with them on important parts of their story beforehand will really assist them in remembering it when it's required and when it's needed. Prepare the court. Prepare the court on the nature of your client's accent if it is Aboriginal English. As part of your submissions, you should always include a few words on the nature of how your client operates in discourse, and this can avoid potentially devastating assumptions on who they are in terms of credibility and believability. So in terms of preparing your client for trial, translating the language of the court is important. As lawyers, we tend to speak quickly. We tend to speak in legalese. It's not easy for many people who are even been in and out of the system all the time. It's not easy for them to understand. Remind your client that you will take the time to explain to them after what's happened. Should your client testify, let them know that the questioning will feel like forever when they're up on the stand. Make sure that you let them know about the potential for aggressive cross-examination and prepare them for that. Remind them that lawyers can sometimes be overdramatic, and that's also something that they should be aware of. And to not take personally that it's also part of the job of the other person who's doing the advocating. Be patient. Clients, even if they disclose intimate details for you, it's on a one-on-one basis. You're their advocate. It is incredibly difficult to disclose that same information in a courtroom, especially if you're working in a small rural community where people may be in the courtroom, people that they have to see every day, people that they're going home to, and that they may feel very uncomfortable talking about what's happened. Aids in testifying. Do not assume that you know what your client wants in terms of aids in testifying. Many communities are still dealing with the after effects of colonialism, especially when it comes to religious or traditional beliefs. Do not automatically assume that your client would like an eagle feather to help them testify. Ask them and canvass them beforehand on whether or not they require a testifying aid and what that looks like to them, and explain what their options are. All right. So, in terms of best practices, and this is going to be the last part of my presentation as I finish up, in terms of best practices, I can't emphasize enough the importance of connecting your client to resources and services. Take the time to learn in your community that you operate and that you practice in what organizations and community resources are available for your client. Sometimes all we see is the organizations that are present in court. A lot of the best organizations don't ever come to court. And that's because court's not a welcoming place. So go out there, get out there into the community and understand what is available. Canvass with your client what type of program or service they want to engage in. Like I said, not all of them are going to want culturally traditional services. Some of them may be more than happy to engage in other services. Indigenous court workers in the courthouse that you work in may be available. They are usually great resources for information. It's important that you go to friendship centers and community providers because you have to understand and realize that the healthier your client is on the day of trial, the better equipped they will be to not only deal with the emotions of the trial itself that day, but to recover once the trial ends, because that is a whole person who's going to be going home and dealing with the repercussions of what's just happened to them that day, and you want to make sure that they have supports for that period of time. Effective representation includes asking yourself the tough question of whether or not you have the time and ability and cultural knowledge to work with Indigenous survivors of violence. The vast majority of Indigenous clients are represented by legal aid. They're funded by legal aid, which means that you're going to have tariffs, which means that you're going to have limited time to work on a file. Working with an Indigenous client may mean that you exceed those hours. You need to be prepared for that. And if you're not, then you need to make the decision about whether or not you are capable and can do the job of representing them effectively. So make sure you have that conversation with yourself beforehand. Finally, take care of yourself. If you've decided that you are prepared and ready to represent a survivor of sexual assault, and you put all that time and effort into gaining their trust and receiving their stories, you need to ask yourself how you're going to process that information. When you hear them and you take their notes, how do you go home at the end of the day? How do you carry that with you? How do you take care of yourself? Because let me tell you, vicarious trauma, as you who work in those harder areas of criminal justice, it is a very real thing, and you will burn out. We get no training in law school on how to accept traumatic information like this from our clients. And lawyers in general are not necessarily a profession that models healthy behavior. The way that we cope is often bravado, and it's tough, and a whole bunch of things in large amounts that aren't good for us. And that's not a great way to deal with these things. Remember, if you're not good to yourself, you're not going to be good to anyone else, and that includes your client. That is my presentation. Thank you very much for listening.
Thank you so much to Caitlin. That was really an excellent, thought-provoking and informative presentation that I think we can all benefit from in all the work that we do. We're going to take a 15-minute break now, come back afterwards with the best practices panel. Please feel free to help yourself to food. There's lots of it. And just don't go too far because we want to start right at 11:30. I know the agenda says 11:35, but we're going to start at 11:30 to make sure we don't let you guys out too late. Okay? Thanks. Because there's 3 mics.
Three, that's all right.
Wow, you guys are so good. You're back right on time. That's awesome. Okay, I'm going to introduce the next panel as they get settled. To my left here is Stacey Hayner. She's a lawyer that's been practicing law in the District of Manitoulin for 21 years. She's currently a sole practitioner providing trauma-informed litigation services to victims of intimate partner violence, sexual assault, and systemic discrimination. She does do defense work, but not in the area of sexual assault. Joanna Birnbaum, who is now to my left, is a litigator in Toronto with expertise in gender equality and sexual violence. She has extensive experience in this area that includes constitutional litigation, civil, sexual assault claims, employment law, human rights, workplace investigations, and she represents complainants in sexual history applications in criminal sex assault proceedings. She also defends malicious prosecution and defamation claims targeting women who have reported sexual violence. She also does defense work, but not in the area of sexual assault. And Ian Carter, he's a partner at Bain Seller Ertel Carter in Ottawa. He's conducted criminal trials in provincial and superior courts across the country, as well as for the Canadian Forces court-martials proceedings. And he's argued numerous appeals at courts of appeal and the Supreme Court of Canada. He has particularly a lot of experience litigating matters involving sexual offenses, representing both accused and complainants. So I welcome the panelists here today, and they are going to be discussing best practices for representing victims. And so I'm going to have a few questions for them, and for the next hour, hopefully we're going to hear their insights, which is going to be very, very, I think, instructive and educational. So the first question is going to be mostly for Ian and Joanna, and that is, given the comments that we've heard today and some of the legal issues that have been raised, what do you see as some of the challenges in these particular applications? Maybe I'll start with Joanna.
Do I need to turn this on now? So one of the great things about us being invited and included on this panel and on this day is that it may be no surprise to those of you in the room and on the webcast to learn that complainants counsel don't always see the world in the same way, not only as defense counsel, but also as the Crown. And part of the reason why Section 276 was amended to give complainant counsel standing was that very reason, was that there was a recognition that complainants needed their own counsel to advocate for and represent their constitutionally entrenched equality and privacy rights in sexual assault proceedings, including in relation to their sexual history. And that there are occasions, and Ian and I and Stacey will talk a bit about these, where the Crown and Complainants Counsel might not agree on a response to either a third-party records application or a sexual history application. And so to respond to Megan Savard's comment this morning that Complainants Counsel is symbolic, we respectfully disagree.
And Megan's not here. That's
Unfortunately, she's not here, and no doubt she respectfully disagrees. But that, in fact, our view is that our role is very important and not just a new hoop that defense counsel or in some cases the Crown have to jump through, but that we're there to represent constitutionally entrenched equality and privacy rights. Which leads to the next comment that I wanted to make, and then I'll turn over to Ian, which is that I think both the Crown and Defense Counsel this morning have presented to you as a matter of law, or as a statement of the law, that Complainants Counsel have no standing on these motions for directions. And as Complainants Counsel, again, I would say, well, we respectfully disagree with that interpretation of the law, and that in these early days following the amendments to 278 and 276, there's growing pains, and at least from the perspective of Complainants Counsel, I would describe, or I've argued in court, that sometimes what these motions for directions can be characterized as an end run around the provisions that now give Complainants Counsel standing in applications where there's records in possession of the accused, or where sexual history is being raised. And our position frequently has been, absolutely we have standing. Either we have standing under the statute understood purposively, or we have standing as a matter of the engagement of our client's constitutional rights. So I have argued that on a number of occasions. I do agree with the statement of the law that was given this morning that generally I've been granted standing as an intervener, but that's certainly not the position that I have taken, and that issue hasn't gone up yet to an appellate authority. I'll see what Ian's views are on that.
Yeah, I agree with Joanna. I think there's a couple of key points to make here. First of all, these motions for directions that have arisen, that's not part of the legislative scheme. This is a judicial answer to the practical problems that have arisen interpreting the legislation. There's nothing that prevents Complainants Counsel from having standing on these particular applications. And then the second main point I want to make is what we're arguing about this at this stage is reasonable expectation of privacy. Who is in better position to argue that issue than Complainants Counsel, who represent the complainant's issue? This is an issue that purely relates to the complainant. Unlike other areas that might deal with admissibility at trial, that's more an issue for Crown, this issue directly engages the complainant, and they have the most direct interest in it. And the third point is, this is an area, and I've spoken with Crown Counsel about this before, this is, in some cases, a Complainants Counsel position is going to align with Crown Counsel. That's the reality of it. Other times, it may not. And you may have a Crown Counsel, and perhaps it's the individual position that they take, perhaps they're less experienced, it could be any number of factors that might concede that there's no reasonable expectation of privacy, for instance, and would be prepared to do that at the hearing, whereas Complainants Counsel are saying, no, my client asserts a reasonable expectation of privacy, and if you're not going to make that argument, then I better be there to make it. So I would agree with Joan on this. I don't think the law is settled on complainant's role. And sorry, I don't want to drone on, but one final point. In the series of Boyle decisions, and it's not directly reported, but it's referenced in one of the latter decisions in terms of what happened because there was an adjournment in the trial, and then Barton came out, and the judge came back and said, the Crown led some evidence that implicates 276, and we didn't deal with that before, but now Barton's come out and said that if you go back to Seaboyer, that's got to be vetted as well, so counsel, let's deal with that. And then as counsel, I said, well, my client has a right to standing on that application, and unlike under the present statutory regime, there's nothing that would indicate for that application that you do have standing. In the context of that case, the trial judge found that in the unique circumstances, without deciding the issue further, that complainants counsel did have standing. So that's an example where you can get standing and make submissions, even though it's not, there's no statutory basis to do so.
And I think those are all fair points, and I think we can hopefully expect lots of very robust litigation in this area in terms of whether complainants counsel gets standing at these stage one. So Stacey.
We're not done. We're not done.
You're not done. I'm sorry. Go ahead. I was going to go on to this next question, but please finish.
Well, the remainder of the questions, we of course know what we've been asked to speak about, don't address the substantive law, and so we wanted to make sure that, I appreciate that there's a number of people who are here today or are on the webinar who don't have their head in this area of law day in and day out and are interested, you are attending because you're interested in possibly taking on this work. And so we just wanted to make sure that you're aware of, again, some of the other approaches to the substantive law that differ from what you've heard this morning. And so, first of all, you heard that, well, if the records are not, there's no reasonable expectation of privacy or are not sexual in nature, then defense doesn't need to bring a 278 or 276 application. And my comment on that is that these amendments to the regime are intended to require judicial vetting to make that determination, that it's not, hey, trust me, defense counsel, that my view of these records can be relied on, that they're not sexual in nature. And I've had many cases where defense's position is these aren't sexual, and my position is they are, and that has had some currency with the court. And sometimes there's a disagreement there with the Crown in terms of whether there's a reasonable expectation of privacy. There was reference this morning to two decisions of the Superior Court of Justice, one by Justice Davies and the other by Justice Roberts, on these motion for directions in determining what are the criteria for determining whether or not there's a reasonable expectation of privacy in text messages. Most of these cases deal with text messages, right? Records in the possession of the accused that the defense doesn't want to run through the regime. And I just encourage you to read those two decisions carefully. They're not ad idem. They're similar. They suggest a similar approach for determining these motion for directions, but they're not entirely identical. And one of the ways in which they differ is that Justice Davies says, well, you need to look at the relationship between the complainant and the accused at the time that the application is brought, and that's what Sharif referred to. So the argument is that because they're, even though they may have been in a marital relationship for 10 years, because they're now adversarial, there's no reasonable expectation of privacy in, emails that may have happened 3 or 4 or 5 years earlier. My view of that is that there is, or there may well be, and Justice Roberts' decision gives a different approach to that question. And other than that, just encourage you to read the Jarvis decision, which sets out the law on reasonable expectation of privacy for those of you who are not immersed in the criminal law jurisprudence.
Fair enough. And I think I will just say, as one of the only Crowns in this room, I think Neville might be the only other one, really the Crown should not be waiving the complainant's rights when it comes to that first stage decision of reasonable expectation of privacy. Crowns may have a view, and if asked by the court, may say, well, Your Honor, I don't think this generates a reasonable expectation of privacy, but ultimately it is the decision of the court who has to make that decision. And so as it's been mentioned, if a court feels they do need the submissions of counsel for the complainant, then that will be something that the court would order. So just moving on to the next question. Stacey, you've done a lot of this work in the north where there are remote communities. What are some of the particular challenges that you face in the north with these types of applications?
Thank you, Jill. I love talking about the North. I'm glad to be here to do that. I didn't really realize, even later in my career, that it was really that different from what you all do, but it is very, very different. And a lot of that has to do with just the huge geographical area that we service. Lots and lots of land, lots of small communities within those large geographical areas, that sparse population, the lack of connection between the communities, the lack of public transportation, the reliance on other people to get you anywhere where there's any services, and then the need to have some funding in order to access those things, and then the overlap between the need to go and access the things that aren't in your community and to arrange to go to the things that are in your community, and how they sometimes conflict, and you have to make hard decisions about how you're going to spend your time, unfortunately. We lack services. We lack specialized services especially. The services that we do have are often have a high vacancy rate, high overturn. We have a retention problem. We have a recruitment problem in all areas of service provision that are relevant to the needs of our victims. It sometimes seems as though complainant's counsel is the first and the only person that the victim comes in contact with that cares, that understands the issues that they're facing, that has any emotional competency at all, that has any sense of what it is to be culturally safe, and who is invested in ensuring that their constitutional rights are upheld, and is invested in making sure that the law is properly applied to the evidentiary basis that's in the application. So it becomes quite apparent the first time you meet that they're relieved that you get it, and the next meeting that you have with them is one that they're hanging on. So I think that might be how it's different, although I've never practiced down south, and I'm sure there's a lot of overlap in what I've just described as far as how people receive you. But I think there is a certain almost 100% desperation, that desperate receipt of you in their lives once they realize that that's who you are to them. So that's my experience.
Thank you. Okay, so the next question, Joanna, we'll start with you here. How can you ensure that you're approaching this type of work with a trauma-informed approach? And what are some best practices for meeting the needs of victims? How specifically do you apply an intersectional approach to addressing clients' needs, example, based on race or gender, ability, sexual orientation, language barriers, things like that?
So Caitlin's pretty much covered it all off with her fabulous presentation, and there's nothing that she said that doesn't apply equally to every client that's come into my office. So I have very little to add to what she said. I suppose I often start off the conversation by saying, I'm really sorry that you have to interact with one more stranger in the justice system, and acknowledging how hard it is. I usually tell them that they don't need to tell me anything about what happened. Almost always the complainant statement to the police is relevant to the application, and so I'm going to know anyways, but I let her know that because that's also awkward and awful. Like, one more person knows about the most terrible thing that's happened to you in your life, and then possibly the contents of your diary or your counseling records. I agree strongly with Caitlin that leaving pauses, having some silence is hugely important. Trauma means that it's very difficult for people to process information, and so giving people the space just to sit with what you've said, and then ask them how, check in with how, look at body language. How are you feeling? How are you doing? Do you need a break? Do you need water? Just basics like that, but that we forget because we're a barrage of words, right, lawyers? And then just building trust, the way that Stacey said, letting them know that we're the one person in this criminal trial process where there's complete confidentiality, which very few complainants know. And they do still very frequently think that the Crown is their lawyer or some version of that.
and letting them know that we're a safe space to be able to ask questions. And so I do find that I answer a lot of process questions because, as Stacey said, there's a charge, and then months and months and sometimes years go by, and not because this isn't, critical of the Crown or VWAP, that's just the nature of the beast, and then suddenly out of the blue, they get a call, or sometimes it feels to them like out of the blue, they get a call from Complainants Counsel saying, hey, I'm on board for you now, and so remembering that we're zooming in and out of their lives in the course of a proceeding where they may feel extremely alienated and isolated.
Okay.
Do you want me to talk about the resource now?
Yeah, sure.
So there's two resources that, in addition to what the ALST resource that Caitlin mentioned, that you might want to look at if you want to do some additional reading or education on trauma. One is Women's College Hospital recently has developed a series of webinars. So it's on the Women's College Hospital website, and it's called Understanding the Commonly Misunderstood Reactions to Sexual Assault, a Curriculum for Criminal Justice Professionals. I can repeat that at the end if you want. And then our written publication, which is excellent. These are both 2020 publications. I was trying to find recent resources for you. Dr. Laurie Haskell and Professor Melanie Randall were commissioned by Justice Canada to do a report on trauma and sex assault. So it's on the Department of Justice website, and it's called The Impact of Trauma on Adult Sexual Assault Victims. So those are two additional resources.
Both excellent, yeah, both excellent resources. And the Women's College Hospital one is interactive. It takes about an hour and 15 minutes to watch. It's really, really educational, snappy. Okay, my next question is for Ian. What makes representing a victim different from representing an accused person in a sexual assault case? Because you're the only one on the panel that really does both sides in sexual assault prosecutions.
I think I'll be relatively brief on this. I think the biggest difference that you're going to encounter is when you're representing an accused person, you have control over the conduct of that case and all aspects of it, from intake, interviews, conducting pretrial motions, the trial. You control the process, and the accused is at the center of the proceedings at all times. And our system is designed to reflect that fact. And so you're there from the beginning to the end, at every step of the way, deeply involved, making submissions, cross-examining, et cetera. When you do work for a victim, it's very different in that you, as counsel, you have a narrow role. Within that role, and Joanne and I agree on this, and Stacey as well, you can make robust submissions. In some cases, you can cross-examine, but you do have to keep in mind that you are not conducting the litigation. Because there's the complainant is not a party to the litigation. And that's a big adjustment if what you're used to doing is running a case on behalf of someone. You're not running the case. You have to accept and appreciate your role is much more limited. Again, be robust, but recognize that limit.
So now I have a question for all three of you. In one or two lines, what would you say makes you competent to practice in this area? What's a core competency for each of you? I'll start with Joanna.
So we're just going to choose one or two each because there's a number of core competencies. So I'm going to choose one legal and one interpersonal. The interpersonal being respectful and listening. I agree with Caitlin again that we're not so awesome at listening. And so, really understanding where that complainant is at and giving her, because it's overwhelmingly women, the space to be able to feel comfortable and tell you that is really important, and sometimes that takes more than one meeting. Jurisprudentially, I would say that a core competency is doing this work from the foundation of the complainant's constitutional rights, that this isn't just about getting through as I said, a hurdle or a hoop that's imposed on accused in the criminal code, but that you are there to do something as important as for defense counsel, where they're anchored in presumption of innocence and rights to full answer in defense. We're there anchored in constitutional equality rights and privacy rights.
Okay. Ian? Stacy, who wants?
I would say, from the legal perspective, because the legislation is new and the litigation is coming, the cases are coming fast and furious, you always need to stay on top of the law. But I would say in these cases, there's an even greater emphasis on this because the law is continually developing. Cases are coming out in rapid fire succession. And, for example, you may file your materials and say you're given fairly advanced notice in front of it, and you file an argument, written argument, a factum. You need to keep checking between, say, there's 3 weeks to the hearing, there could be a new decision in that period of time that you need to be aware of. That, like, more than any other area of the law, you have to, right up into the date of the hearing, just get on Quick Law or Westlaw or whatever you're using and just do it, because there could be, and I've had this happen before, where there's a bombshell decision that's reinterpreted, whether it's the motion for directions or otherwise. I think you have to really stay on top of it. It may settle down in 6 months, a year, but for now, you really need to stay on top of it.
Very good point.
I don't have anything to add. I agree with my colleague.
I know that Megan and I have done training we've done judicial conferences, like or bench and bar conferences, and literally like the night before we're supposed to go, some bombshell case comes down. Like RSA came down the day before we were doing a bench and bar in Toronto, and all of a sudden we had to include it and change our slides and everything. So I agree, it's rapid fire litigation for sure. Ian, you, of course, had talked about the notion of representing both victim and accused, and obviously you can do that. How do you ensure that there's no conflict of interest? In other words, if you've represented an accused, let's say at trial, where the victim that's now approached you was a witness or a complainant, how do you deal with that, even to know that there's a conflict?
Well, there's sort of two aspects to this. The first one is pretty straightforward, which is your usual conflict issue. And if anything, there's fewer conflicts representing complainants than there are in other cases. When you're representing an accused person, there could be any number of witnesses who you or a member of your firm or someone you're practicing in association with might have represented, and that can cause a problem. Coming back to the point that your role is limited here, there's fewer opportunities for conflict. One thing you do, if you operate in a firm or in an association, you have to have that discussion with the others involved, because the conflict that can occur is, and we've had this happen at the firm, is I'll get a call from the complainant first, and a partner might get a call from the same accused half an hour later looking for representation. If you're representing the complainant, you're conflicted out, anybody at your firm is conflicted out. So that's the obvious thing, and you need to have that conversation within your firm or your practice if you're going to do this work, to recognize that that's the major complaint, the conflict that can arise. A second issue, and I think I'll address it now, we were maybe going to address it later, is not a conflict in the technical sense, but it was put to me this way. What if you take a position when you're defending someone about the legislation, and you're taking an opposite or different position when representing a complainant? So I thought long and hard about this question, and my answer is this. For fairly routine stuff where you're applying the facts to the law, and the law is settled, I don't think any conflict arises. Your role is to represent your client's interest, and within the legal framework, you can make your argument. I don't think any conflict arises. Where it might be more problematic, and coming back to the point that the law is really developing on this, say for example, you have a situation so in one case, in the Boyle case, I argued that on a 276, a complainant has the right to cross-examine. And Justice Doody found that that's correct, and there is an ability to cross-examine. That's an Ontario Court of Justice decision, and someone else, a Superior Court, the Court of Appeal, may at some point take a different position on that. What if you have a client that comes in and said, that you're representing, and says, I want you to challenge that position. I want the complainant's counsel shouldn't have any right to cross-examine me, and I have just made submissions, and that's the state of the law. I think that is a potential situation where there's a conflict, and you need to have, it's not a technical conflict in the sense that is referred to in the case law, but I think it's one that puts you in a difficult position with your client, and you need to have that discussion, and probably, if that's the position they want to take, can't continue to represent.
Joanna?
I just wanted to give another similar example. So Megan this morning was talking about, because she's litigating this, and she's probably not the only one, which is the issue of, does complainant's counsel get the entirety of the 276 application, or is that a breach of charter rights of the accused, because then she sees what questions he wants to ask, or if it's text messages, the content of those messages. And so she and other defense counsel have taken the position that complainant's counsel only gets a redacted, if any, version of the application record. And, I would be concerned of a similar conflict of interest if you as defense counsel are taking that position on a motion for directions under 276 on behalf of an accused, and then when you're representing a complainant, don't demand or ask for the full 276 application because that's your view of the law, when at least at the moment, that's not settled law. I mean, if at the point that the Court of Appeal says that's what it is, fine, but at the moment, the regime, at least in my view, and complainant's counsel views, that the complainants do get the application. And just in case any of you are litigating this anytime soon, just remind you that paragraph 9 of the Derrick case, so we're 20 years ago now, said that the Crown, even when it was just the Crown sharing the contents of a 276 application with the complainant, that the Crown had a duty to discuss the content of that application with the complainant. So from our perspective, it's done. The Supreme Court's decided this already, but it's got to, go up, and maybe we'll be wrong, but...
And I will say, I didn't have time earlier to talk about the constitutional cases, but certainly two of the constitutional cases in Ontario, I can't remember the two, AC and whichever one, the other one, JA or something, they were the ones where one of the arguments was exactly that it breached under Section 7 and 11D the accused's right to silence and right to a fair trial because the complainant was now going to get a telegraph of what the defense case was. And the courts both said, there's no basis to that because it's been argued at the Supreme Court, both in Dara, as Joanna just said, and also in Mills in the context of the third-party record proceedings. Because in those proceedings, the complainant would get the whole application record, and they said that doesn't amount to making the provisions unconstitutional, and so they upheld the legislation
That was the argument
for that.
in Quinnell, too.
In Quinnell, too. So, good point. Okay, my next question is for Joanna and anybody else who wants to join in. The Supreme Court decision in Barton, which we've heard about, and previous Supreme Court jurisprudence dictates that the experience of a sexual assault complainant in the criminal justice system must be enhanced by ensuring that myths and stereotypes that have no place in a rational and just system are properly eradicated from the criminal justice process. So as victims' counsel, how do you ensure that that's done?
So I think this kind of answers the previous question too, of what's a core competency. And I would say that a core competency of complainant's counsel is actually being able to see and articulate rape myths that are otherwise perceived as common sense and not as discriminatory reasoning within the justice system, whether by defense, Crown, or the court. So our role, and that's another reason why it's important to have complainant's counsel present, is that we are trained and sensitized to the discriminatory assumptions that still pervasively inform and influence the arguments that are made in sexual assault cases. So that's our unique expertise. Another way in which we perform the role required in Barton, at least I do, is that you try to make it real for the court. So I come to the court and you try to convey the lived experience of your individual complainant as well as complainants systemically to the extent that that's relevant. I mean, it's not relevant in every single case. Some cases are pretty straightforward. But I try to do a reset. And I don't know if this is other people's experience in the room, but I found that since Barton and Goldfinch and RV, judges are much more sensitized or alert or listening than they were before. But even still, even though we're now 6 months hence, I will do the reset where I'll in really brief form and apologize if I'm making submissions that the court's already familiar with. But We'll explain what's the purpose of these provisions, how it is that they came to be in the criminal code, and why they, in real terms, impact the experience of this complainant and the willingness of people to come forward. And in records applications, I still find very frequently the submission of defense counsel is, well, it's not, it's not such a big invasion of her privacy to pass up her records that they're only being seen by the judge. That's, a minimal invasion of privacy. And so I always put in my FACTA the paragraph from O'Connor in Justice Laura Dubé's dissenting provision, where she explains how even production of private records to the court is an invasion of privacy. So just doing that, that reset. And then just briefly, the other way I think it's not really addressing the stereotypes as they find themselves in court, but the thing that I'll sometimes do with complainants, depending on what role they want me to play with them, is just to tell them what to expect. You're going to be told that you're a liar in some way or other. Oh, there was delayed disclosure. Okay, well, it's an error of law to draw an adverse inference, but you can be asked all kinds of questions about that. So just preparing the complainant for the categories, not the specifics of a case, but the sorts of rape mythy questions or questions that will be experienced as rape mythy. So it's not quite, it's still terrible, but it's even worse if you're not expecting it.
And can I just ask a question, Joanna? So what you're talking about there is not necessarily representing a complainant on one of these, call it Bill C-51 hearings.
No.
You're talking about just giving a
General.
complainant advice behind the scenes about what the experience is going to be like.
Yeah, it's the sort of generic thing that, if you went to complainant school, the minute you're thinking of going to the police or the minute after, you should be directed to, a website, which is not very personal, but that, that would tell you those sort of general things to help prepare you for what's about to come.
I'm going to put in another pitch for the article that Joanna commended to you from Dr. Haskell and Professor Randall. And they, in their article, they speak of the uniqueness of sexual assault prosecutions, which I think we're all familiar with. They're very heavily relying on, almost totally relying on the complainant's evidence. So the focus is always on credibility. It's and it seems to lend the court to treat them as cases where anything that will tell me anything about the complainant's credibility has to be relevant. Because how else am I going to decide this? Justice Duty put his hands up and says, how am I supposed to know who's telling the truth and who's not, So that, and the Dr. Haskell and Professor Randall talk about that, how unique that is, and then I see that play out in the courtroom when we're in a sexual history application and we're talking about sexual assault. And I'm watching the narrowing of the scope of the accused person on the stand, the cross-examination of the accused person on the stand, and I'm very experienced trial judges saying, no, you can't go there, no, you can't go there, no, you can't go there. This is the application pertaining to the Section 276 application only, And how is that relevant? How is that relevant? And it inspired a submission, my submission to the court, that what if this was an assault trial? What if there was no corroborative injury, which is often the case in sexual assaults, there's no corroborative injury, and it's an assault trial. Do you care very much about the prior relationship and whether it was what type of relationship these two guys in a bar fight had before the bar fight? Do you want to know about every fight they've had before the bar fight? Or do you want to know whether or not he started it or he started it and what steps that person took to ascertain the consent of that person? So you, in watching you here today, Your Honor, you would narrow the scope of that cross-examination hard. You would narrow the scope and you'd say, don't even go there. I'm not listening to it. It's irrelevant. We lost badly. The decision just came out and heavily relied on Harris. And, but but it was a powerful argument, and it won the day in court. I had the popular vote, and it felt good, and lots of good words were said to me after about, just how powerful of an analogy that is. But that just speaks to, I think, what's underlying here when we're dealing with peer credibility cases, and that's what sexual assaults generally are, that they just make the court almost like, how am I supposed to decide? Give me more, find something that, they're inconsistent about so that I have, a way to decide this case. And unfortunately, that's the reality we're faced with, and we have to keep trying to find powerful, I think, analogies that bring the court back to situations that they're more comfortable dealing with, quite frankly.
I don't have anything further on this one.
I think that's a really good point. And, we do have Supreme Court and Ontario Court of Appeal jurisprudence now, ARJD, ABA, Lacombe, and these are cases where the courts have said that triers of fact, whether it be a judge or jury, can't rely on stereotypes in terms of how they think a complainant should behave. And there is jurisprudence that says, although, I mean, it's not determinative if a complainant delays in disclosing or has post-offense contact with the accused or goes to get a pedicure the next day after she says she was sexually assaulted. Those things aren't determinative of the fact that she was that she shouldn't be believed, that should undermine her credibility. But whether the questions can be asked in a non-judgmental way by counsel, just as being relevant to her narrative, and whether or not at the end of the day the court can use those pieces of evidence to determine her specific credibility, not the credibility of the mythical or stereotypical sexual assault complainant and what one thinks they should do, but hers. That's, I think, where the tension lies. But I agree with Stacey. If we take it back and we look at if it's an assault case or a robbery case, you wouldn't care about all those questions, right? Okay, so my next question is really for all of you to answer, or whoever wants to, but how time-consuming is one of these retainers, especially responding to a 276 application or even a records application? And do your responses have to be in writing, especially if it's a mid-trial application? Can the work be done without properly meeting or meeting in person the complainant and spending time with the client? Stacey, you might have some different thoughts being in the north, but why don't we start with Ian on this one?
So I think the short answer is it depends. It depends on the case, it depends on the client, but I would, Caitlin's comments earlier, I think applied generally, and in these types of cases when you're meeting with the client, you need to take maybe more time. When I'm representing someone who's accused of committing an offense, I certainly take the time with them, but my focus is on directing them to the task at hand, and I'll say, look, you've retained me to represent you on this, and you want a good outcome here. Let's stay focused on that. I think when you're representing a complainant, you need to take a little bit more time, maybe not direct it as much, and that is going to be a bit time-consuming. One of the reasons why it varies is it depends on, for example, on the 276 application, what the application materials are like. Sometimes they're very well done and they're detailed, and other times defense counsel has just thrown up a general application with not much detail and no real evidentiary basis for it to go further. And the same is true with 278. And so one of the things that you want to look for as complainants counsel, is there a way for me to cut this off at the pass at an early stage by making an argument that the requirements for the judge receiving the materials, or in the case of a 278, for instance, aren't even met because they haven't identified how it's relevant to a defense particularly. And the case law is clear from Dara and from Mills and otherwise that that's a requirement. And I find it's often missing. And so sometimes if you cut it off in the pass that way, that requires less information from the client and is less time consuming. That doesn't always work. And sometimes what can happen, depending on what judge you get, is the judge, they're often reticent to have to end the application at that stage and may say, well, counsel, what about redrafting the affidavit? Or I've even had a judge politely suggests that maybe the accused should get in the box and flesh out the affidavit. So it doesn't always work, but but that's something to sort of keep in mind. I think there's a panel that's going to talk about the funding aspect of this, and under the funding arrangement, it's essentially monitored by legal aid, and they have limits on the number of hours that you can do. And again, coming back to Caitlin, I think you have to be prepared if you're taking these cases to going above and beyond that, and be prepared to do that, and that part of your representation at that point might be on a pro bono basis.
Stacey?
I agree with my friend when he emphasizes the need to study the evidentiary basis for the application and see if it pans out with the assertions made in the application, because that's often where, I mean, you have to start there. You have to zoom in on that and go there, because if you don't, and you assume that it's going to just, be argued in submissions or whatever, you miss an opportunity to have the applicant put before the court something that actually does support the assertions they're making in their application. As far as meeting with people, it's obviously essential that in order to get proper instructions from your client, you have to meet with them, you have to put the application before them, they have to understand what's in there in order to give you proper instructions. A lot of what we do is at the last minute, unfortunately. The applications are coming to us through the Crown, to the complainant sometimes first before they come to counsel. That's just the reality. And then you have to get to your client in order to get the application from them, unless someone's nice enough to scan and email it to you. There's a lot of time constraints. The geographical constraints are huge for us, and a lot of the people that are in the north making complaints in the north to the police and then prosecutions are following are people from away. So you end up with clients in London and Toronto, and because they've come here to go to school, or they've come here for summer vacation or whatever. So, but it's crucial you set up your phone meetings. Unfortunately, that's the best you can do sometimes, or you try to do something through FaceTime or Skype. But you have to get that information from them to properly represent them. And if you're not going to be in a position to make oral submissions because of the time constraints and your lack of availability, you need a waiver from your client to not be there. You can't just simply put in paperwork and say, please consider our position. I mean, you've got to explain to your client, otherwise you got to seek an adjournment. And it doesn't make you popular at all.
What part of the question was just what's this going to look like for your practice? And I don't know, probably everybody on this panel agrees. So this is a labor of love. This is not like, the income earner for any of our practices. It's incredibly disruptive to whatever other, work you've got on the go. Much of the time, not always. Some of the courts like Brampton and at 361, sometimes they're scheduled way in advance. So it's not always last minute. Sometimes they really do comply with the rules and then some. The code. You could tell I'm a civil litigator. But the main thing is that we do, the complainants counsel that are in my network, hopefully they're out there, that I'm speaking correctly for all of you, that we do this because we really care about it, and that's what drives the work. And so because of that, we'll put up with the hours that are lost because you spent time with the complainant and then it gets abandoned, or, you get a call and it's last minute and they need somebody and you don't want, eye on the prize, you don't want the trial to get adjourned because of a last minute application. So you're reaching out to everybody to find somebody else to represent her, because then you feel an obligation to that person who's picked up the phone and called you. That's what a lot of the life of this looks like. And not all of them are time consuming. Some of them are that there's a 16-hour cap, but many of them take less time than that. And for those of you who do legal aid work in the GTA, you'll also know that you could spend more time driving to Brampton and Newmarket than you do in court, or sometimes on the application entirely. So again, is this an awesome bottom line part of your practice? Probably not. But it's, it's very good work if you care about it.
And I would assume that the more you do these types of applications, the more proficient you get in this area of the law, and can your work be a little bit more efficient in that?
Do you know what? I know that Ian said law is changing all the time, and that is true right now, but most of these cases turn on the facts. So I don't actually find that it's that much faster, because what you're doing is looking at the application, you're looking at the prelim transcript if there's been a prelim, and you're looking at the statement to see whether or not there's a basis for the application, and that just takes the time it takes.
Okay, so Ian, for instance, your communications with your client, or actually for all of you, your communications with your client are privileged, but inevitably you may or will be involved in conversations with the Crown and making submissions in court. So how do you protect client confidentiality in that regard?
Okay, well, there's sort of 2 points I want to make here. The first one is this. I mean, it seems obvious, of course, with any client, you need to protect solicitor-client confidentiality. What I think arises here is often it can feel like you're on the same side as the Crown, and when you're dealing with the application, you're going to have conversations with the Crown, but you can never lose sight of the fact that communications that are made by a complainant while she is seeking legal advice from you are protected, and you cannot share those even with Crown Counsel without her consent. So do not forget that rule, because it can be easy to forget when you're sort of working with the Crown, who seems friendly, but it applies throughout. And then the second thing is, and I learned this the hard way. As there's a role for counsel to deal with the complainant, and the complainant's going to, raise a number of issues, and you're going to go over factual things. And in a case, what I had happen is, while she was being cross-examined, she said, "Well, I did that because that's what my lawyer said." Okay, and so remember, you're not, generally speaking, I happen to be in court to watch your evidence. That's, if you're under one of the funding orders, that's not normally the case. I happen to be there, and you can just imagine what that felt like sitting in the back of the courtroom as that bombshell dropped. And you're not a party that can get up and object. And with the greatest respect to the Crown, who I love dearly, did not exactly get up fast, and the questions continued for a bit before they eventually did. And that the judge's immediate reaction, no, she's waived privilege, the Crown. And so then I had to, luckily I was in the court, and the court called on me to address the situation, and it was determined that I would be able to communicate with the client solely for the purpose of finding new counsel to deal with the waiver of privilege issue, and that I couldn't continue to act for her generally. And then the defense was saying, well, Mr. Carter is a witness now, and so then I had to get my own counsel to deal with that. So in your conversation with the complainant, it might be a good idea to explain that if they're asked questions, they are not required to answer stuff about conversations with a lawyer. If I had provided that advice during our meetings, perhaps I wouldn't have ended up in the situation I was in. So that's sort of a practical point to keep in mind when you're dealing with these.
I actually have to say, I do always tell clients that without knowing this story, but now I will never forget to tell them that. And I tell them, and if you're asked a question about, did you see a lawyer, pause so that the Crown has time to get up. But it doesn't arise all that much. I don't find that issue arises all that much. It sometimes comes up when, when the complainant, you're actually meeting with her, and then you find out that for any variety of reasons, she doesn't want to go ahead with it. So then sometimes I'll ask consent to talk to the Crown about, can I communicate that to the Crown? Do you want me to explore whether there's an 810 resolution? That's really one of the only ways I find it come up.
And so I have a question just on that note for anyone who feels like answering. Is there a privilege in the fact that, forget one of these statutory applications where the complainant has statutory right to counsel, but often a complainant will get advice either through the independent legal advice pilot project or just advice from a lawyer about how to go about the trial, maybe some advice on how to testify. Is that relationship in and of itself privileged? And I ask because sometimes, as the Crown, we will get questions from the defense. Does the complainant have a lawyer? Has the complainant consulted with a lawyer? Or maybe that question is asked of the complainant in court. Have you spoken with a lawyer? I would get on my feet and say, I think that's privilege. I think the fact that they have a lawyer is nobody's business. But I'm curious as to what...
I agree, but if it comes out, if you know about it, then it's harder for you, but I agree.
That's why I always say, don't tell me.
Yeah.
Don't tell me if you're in therapy. Don't tell me if you have a lawyer. Any comments? No?
I'm not, well, as much as I would
This is
like
not a
to say
planned question,
otherwise,
so
I'm
in
not sure
fairness-
the identity, if they've retained a lawyer, I'm not certain that that's a privileged communication between lawyer and client necessarily that would be covered. I'm not certain that that's the case.
The fact of the retainer.
The fact of the relationship.
Right.
Okay, can I ask you, does that question ever come up in trials other than sexual assault trials?
Never.
Right, so there's the problem.
Yes.
Relevance, right? Like, what's the relevance?
There's no
Yeah,
relevance. They're
it's-
not going to be able to get at the communication, so what does it make the difference?
It's an,
right?
it's
How is
an
it going to be relevant
inference
to the
that
trier
sexual
fact?
assault complainants are more likely to lie, and they've been
Right.
coached by their lawyer to, massage their story.
Right.
That's the inference.
Yeah, and the Supreme Court has said there is no factual basis for the fact that sexual assault complainants lie more than any other complainant. Okay, so I don't have any more questions for this panel, but they've done a great job. But I want to, just because we do have maybe a few minutes, if anyone here in the room has a question for any of the panelists, if anybody wants. Do you want to just go to the mic, if you don't mind, so that the people who are at home can hear?
This question is directed to Ian, and I was just, if I understood you correctly, you had said that you were granted the right to cross-examine in the Boyle case? Is that correct?
Yes.
And then, could you tell us, was that a private retainer then from that point? Or was it pro bono, or,
I can't,
Okay.
unfortunately, I can't discuss that, no.
okay.
But
Sorry.
But I would think, just to answer, I mean, I won't put
Yeah,
Ian on the
yeah.
spot, but I would think that that would be part of the appointment of counsel on a 276 application. Because that appointment of counsel, and we're going to hear about that in the next panel, but when a hearing has been ordered under either 276 or 278.92, as Megan and I talked about earlier, that crystallizes the statutory right of the complainant to the right to appear and make submissions and the right to counsel, leaving aside whether counsel has standing or should have standing at stage one. Once that happens, the Crown will ask for an order appointing counsel to be signed, and that is effectively the order that would be provided to complainant's counsel that they would use when they then send it to legal aid with their invoice. But that order appointing counsel would apply for complainant's counsel to represent the complainant on that hearing, and that is what the case law has interpreted to include cross-examination of the accused on the 276.
Yeah, I guess, I mean, what I can say is this, like, outside of case specific, I can say that I'm of the view that conducting a cross-examination under 276 would be covered by the order that you get with respect to funding if you had it in a particular case. So if that's what you're wondering, the answer is yes.
But can I also say, it's nothing new. We've had the right to cross-examine counsel under the accused if there's viva voce evidence, under 278s for over 20 years. And it doesn't come up all that much, but I've cross-examined.
On third-party record applications?
On third-party record applications, yeah. I mean, in 276s, I personally have generally chosen not to exercise that right because the Crown knows the case better than you do, and it's often, at least in the cases I've had so far, often not necessary, but it's not something new. It's been around since 1997, in my view.
So if I can just add to that, despite that fact, and that when I argued this issue, because I wanted to look at the parallel for 278, this is what I was told, that there's, we've been doing this for 20 years. When I went to look to find case law, I found one case from Manitoba. That was it. So it was done, but there wasn't much jurisprudence. In the Boyle case, in a previous ruling, Justice Duty had sort of said, even though it wasn't directly at issue, that cross-examination wouldn't be available on a plain reading of it because it says appear and make submissions, and then ultimately what he found was in order to do that meaningfully, you need to be able to cross-examine. But to come back to Joanna's point, I think it's an important one. Just because you have the right to cross-examine doesn't mean you should exercise it. You need to think carefully about whether there's anything that you can add, because the Crown does know the case better. They know the full case. There may be things that the client has told you in conversations that might be relevant that you want to cross-examine on that the Crown is not aware of, and that may be a role for it. And you know, especially as defense counsel, you love to cross-examine, you can't wait to do it, but you have to think carefully about whether you're adding anything or you're just creating more problems in there. So think carefully about it before you do it.
And the only thing I'd add is there is a distinction between the scope of someone's retainer and what they're funded to do. We get orders appointing counsel, and as a result of that, I can bill the funder for certain services that I provide to the complainant. However, I do a retainer agreement with my client, which may cover things that are not funded, and they may contain things that I do advocate for, and I speak on behalf of the victim for, to the Crown, to the defense, whatever. And I get back from often the Crown, that is outside the scope of your retainer. And I say, okay, I'm not being funded by the ministry to provide this service, but what do you know about the scope of my retainer? Nothing. Okay, so let's move on, right? So if there's something she wants changed in the conditions that were given to the accused at bail because it's making her uncomfortable and it's been raised by VWAP and nothing's been done, and she wants me to write a letter, I'm going to write a letter, and I don't want one back that says this is outside the scope of your retainer, thank you, I know what my retainer says, and it does include this, but I don't have to tell you that. In fact, I can't tell you that, so yeah.
Okay. Well, thank you for the very informative panel. And just now, as this panel leaves, I'm going to ask the next panel to come up, and maybe could we have somebody change the PowerPoint? I don't know if there's someone outside who needs to change the PowerPoint. Yep, okay. So just I'm going to introduce our next panelists who are going to talk about lawyer referral and payment process. Rena Parnes, who is to my left, is lead counsel at the Ministry of the Attorney General's Victim and Vulnerable Persons Division, Ontario Victim Services. She's been there 10 years, and you would know that as Victim Witness Program. She's basically the head of that. She also, prior to that, worked at the Barbara Schleifer Commemorative Clinic and the Human Rights Commission, and she's very well versed in this area. Lisa Bernstein joined Legal Aid Ontario in 2003 after a decade of practicing family law. She's worked in various capacities there, from direct client service to policy and external relations, and she's currently general counsel at Legal Aid General Counsel Office. And so welcome, and I see the PowerPoint is already on. Do you have the...
Good afternoon, everybody. We are in the lucky position of being the last panel of the day. So we understand this is Saturday, and you're probably looking forward to having the rest of the day to yourself, so we won't be too long. What we're going to really do right now is do a little shift in focus. So you've learned about today the legislation, the case law, working with victims and representing victims and best practices for doing so, and more specifically working with Indigenous victims. And now our focus is going to shift to some practical information about how you can get involved in this work. And in a nutshell, what we'll be covering is how might clients get to you if you are interested in doing this work, and as well, how will you get paid. So I'm just going to briefly go over the process for victims to obtain legal representation. Some of you might already be well aware of this process and experienced in this, but for those of you who haven't done this work before, I think it's helpful for you to know how victims do get connected to counsel, and more specifically, ultimately, if you're looking to do this work, how you might be connected to a victim. So the first step is that the Crown will advise the victim witness services worker that an application has been made, and that services worker will contact the victim to inform them that that there is an application. And in doing so, they will give them a very brief explanation about the type of application. And just to be clear, at this point in time, they're not going into anything substantive about the content of that application. They're just explaining that an application pursuant to 276 or an application pursuant to section 278.92 has been made. So they're obviously doing it in much more plain language than that, but just explaining in general what the type of application is and what they can expect moving forward. And then the victim is also informed at that point that if a judge decides to hold a hearing, they have the right to appear and make submissions, and they also have the right to be represented by counsel at the hearing. And so at that point, they will be asking the victim that, you know, should a hearing be ordered, would they be wanting to have representation? And if the victim does wish to have representation at the hearing, the worker will assist the victim to identify counsel. And there's a number of ways that this happens. The victim may already have a lawyer in mind that they either have been working with before, or they're, they know of that they would like to have representation from. And I'm going to go on the next slide, I'm going to go into a little bit more detail about how counsel is identified, and if you want to do this work, how you can get on a lawyer referral list. And then once counsel is identified, the worker will provide the lawyer's name to the Crown, and the Crown at that point will seek an order appointing that counsel for the victim once the judge decides that there will be a hearing on the matter. And for those of you who haven't seen those orders before, in general, the order specifies that Legal Aid Ontario will be managing the account pursuant to the Ministry of the Attorney General Legal Aid Ontario Protocol for Management of Court-Ordered State-Funded Counsel, and it further specifies that that the lawyer will be paid at legal aid rates, and that counsel agrees to abide by Legal Aid Ontario's policies and procedures, including authorization for disbursements, monitoring and review of accounts, billing practices, and payment rules. And Lisa will be going into more detail on that shortly, about what those processes are. And then once the Crown has obtained the order appointing counsel, the Crown will then provide that order over to the appointed counsel, and then it will be up to the appointed counsel to provide that to Legal Aid Ontario. And I've put on this slide where that order should be submitted to, which is the Protocol Case Management Office, or the Protocol Case Unit, at the email address provided. So some of you might be wondering, what is the process for victims to get connected with a lawyer? And if so, how do I get on a lawyer referral list? So as I've stated before, there's many different ways that a victim might be connected with a lawyer. They may have someone already in mind that they wish to represent them. They may have already engaged with counsel and have representation. They may wish to speak to family and friends about a referral, and as well, they may wish to do their own research about who to retain to represent them. All of those are perfectly legitimate ways for a victim to obtain counsel, but in some cases, a victim doesn't have anyone in mind in particular and is seeking assistance to identify counsel. Currently, there is no specific referral list for representation for victims on Section 278.94 hearings. Some of you may be aware of the Legal Aid Ontario's O'Connor Mills panel for third-party records applications. And since Bill C-51 came into force, victim witness services workers have been using lawyers who are on that list, or other lawyers who have self-identified as having the ability to take on that representation, and that's what we've been using to date. But with this training, we're hoping to identify more lawyers who are interested in doing this work. And following this training, a referral form link will be emailed to participants, and should you wish or be interested in doing this work, you can fill out that form. It's, of course, voluntary. And the form will ask you some basic questions. So the questions will be about your contact information. It will ask about spoken languages. The reason we ask about that, and we're looking at spoken languages other than English, is that some victims are much more comfortable with accessing someone in their first language. However, if there isn't someone who speaks their first language available, interpreters are available to be booked and can be used. It will also be asking about your willingness to travel to other court jurisdictions. The assumption will be that where your office is located is normally the jurisdiction that you practice, but we are also aware that you may practice in other jurisdictions or may have satellite offices in other locations. And normally victims will be referred to somebody who is in the local court jurisdiction. That would be the standard. However, there are some areas, particularly rural and remote areas, where it might not be possible to find somebody who does this work in that area, and we'd want to know if you might be willing to travel to another jurisdiction if we can't locate someone locally. We're also going to take this opportunity to update the third-party records applications representation list. You'll be asked about whether you're interested in doing that work, and as this training hasn't really gone into that area, we'll also ask whether you have any previous experience representing victims for those types of applications. And then in general, we'll be asking about your general interest in the work. I just want to take a moment to just flag that before requesting to be added to the referral list, we'd ask that you please really think carefully and reflect upon today's session, reflect upon what this work entails, reflect on some of the best practices that have been discussed in the previous panel about what it means to represent victims or complainants in relation to these applications. And, and how this might fit into the overall context of your current practice. Victims requiring representation may be provided with the referral list to assist them to select counsel, and referrals are made on a variety of different factors. They're based on the location of counsel availability, so if the hearing dates are already known, we definitely want to not cause any further delay in proceedings. And spoken languages of counsels, as I referenced before, and also we do look at feedback that have been received from victims regarding their representation and their experience with lawyers. Lawyers on the list might receive a call from a victim services worker, or in some cases in the Crown regarding their availability. So I'm now going to turn it over to, to Lisa, and she can talk about LAO practices.
So I'm guessing that many of you in the room have worked with legal aid in the past on regular defense work, but when you're dealing, and if you choose to deal with the victim's work for these hearings, you'll be dealing with a very different unit, the protocol case unit that's been mentioned already by Brenna. And so the application process for these certificates is similar but different. The way that these applications are processed, they go directly through the protocol case unit by way of an application that's submitted by an email. That's what we receive on our end in the protocol case unit is we receive the actual order that has the agreement, and generally what we receive at that time is that there's going to be counsel that's named on that. Legal aid doesn't, we do not keep a panel of lawyers for these particular hearings, the 278 hearings. So when it comes to us, we're generally just processing that order and issuing a certificate based on that order for this distinct service. The certificates are issued in the solicitor portal, so you're probably familiar with the portal, and they're generally, we try and turn them around because I've heard earlier today, sometimes you find out about these at the last minute. They're very short notice, so we try and turn the certificates around within 2 to 3 days. That's our best practice. And the certificate that you will receive for work on these files, it's 16-hour allotments for prep time, plus however many hours for court. I'll touch on that a little bit, like in a few minutes, but that's the certificate you get for these services. So once you have post-hearing, you've attended and you've already done your hearing, the way you submit your account is, again, through the LAO portal. So typical, you submit your dockets and all the prep time. Everything, the arrangement, the protocol arrangement that we have with the ministry is that you're going to follow LAO's policies and procedures for billing certificates under the tariff, right? So that's going to be your prep time. If there's disbursements that were incurred, if there's travel time that Brenna had alluded to, you know, it's not always easy to find lawyers that are in close jurisdictions, so you may have to travel. You can submit that on your prep time, and however many hours you took in court for the hearing. The hourly rate that you bill is based on the 3 tiers of the LAO tiers, and those are not just based on year of call. Tier level is, you know, generally based on the type of work, how long you've done this work. There's a calculation, how it's done, so you probably already know what tier level you're at. When these accounts are being reviewed, regular accounts in the portal are done, you know, electronically. These ones actually have live, real people that review them. They go over it by hand to make sure that everything's in accordance with our policies and procedures. And with the 16-hour allotments, if you do go over, because I'm hearing that these cases can take more time, you can ask for discretion. Discretion's a funny thing because, you know, I don't want to sit here and say, you can ask for discretion. It's like the D word. You don't, you know, I say it cautiously, but, and it's in italics, right? May be applied. Having said that, and this is anecdotal, you know, I don't know how many, you know, I spoke to the assessment officers that deal with these matters, and they said some go over, but a lot of them go under, so are under the 16 hours. So people don't always bill the 16 hours. Some cases are shorter and some are longer. So you know, but you know that if it is taking a lot of extra time, you can ask to be paid over the time that's allotted. And I also wanted to touch on your legal aid is going to pay for what the order says, like for this particular hearing. One of the panel lawyers said they could also have a retainer for other distinct services that's outside of LAO's, that what is mentioned in that order. We will not pay, if the judge said, I'd like you to, you know, be a support person for the accused through the trial, we can't pay for that. That can be a separate part of a separate private retainer, but it is for this distinct hearing. That's part of what's stated in the order, and that's part of the protocol arrangement between the ministry. So I did want to highlight that. Once you submit your account, we do try to pay within 30 days, and that might be, I don't want to say 21 days. It may be different than regular certificates, but we try to pay them as quickly as we can. That's about it for payment. Oh, I wanted to, and finally, everyone's favorite topic, your professional obligations. I've said we don't maintain a panel, and for these particular matters, but we do have, we have panel standards. And, when we deal with lawyers under regular criminal certificates or these, we do want to ensure that the lawyers are maintaining, standards in accordance with the rules of professional conduct pursuant to the Law Society Act. So, Chapter 3, you may want to reference that. Take a quick read. For those junior lawyers here, you're probably very familiar with the rules of professional conduct because they're definitely taught in, the bar admission course. For the more senior lawyers, you may want to re-familiarize yourself with them because you may not reference them that often. But specifically, conflicts under 3.4, I know that someone had mentioned the issue of conflicts earlier. Because we don't maintain any panel, we're not doing any conflict checking. When, we get an order, we just send it, we issue a certificate. We're not doing any internal checking to make sure that you don't have a conflict. That's definitely under your own professional obligation, and you should just make sure within your firms and the work you do, especially because this is victims' work, and there could be conflicts based on accused or co-accused or whatnot, just make sure that you have your own conflict checking system in place in accordance with the rules of professional conduct, and to ensure that you can do this work on a case-by-case basis. And I think that is all, subject to any questions.
Is there anyone that has a question that's in the room here for any of the panelists? Yes?
Just a quick question regarding funding. So for the complainant, when they're asking for the order, is there a financial check through legal aid, or simply as the judge appoints it and provides the order, that's done?
These particular applications, they're not subjected to legal aid's financial eligibility test.
Is that because of legislation, or is that just due to the policy of legal aid?
It's government policy.
It's because they're funded by the government. They're managed through legal aid, funded by the government.
I see. Okay, thank you.
That was actually going to be my next question. With the changes to the Legal Aid Services Act, are we expecting that funding for this will now be taken out of legal aid's budget as opposed to them just managing it?
Well, these particular hearings are not in the new legislation. These are if you read the legislation, it does not reference 278.94 hearings. So
this is still going to be funded by the government? Or like separate from legal aid?
Correct.
Okay, great.
Hi, I have a question that kind of goes beyond the scope of what we've heard today, so if it's too boring, let me know, but if someone has the answer, I'm happy to chat. So I've been approached by a legal aid clinic to represent them at essentially the subpoena stage. So it's the social worker whose records are being requested by the court, and they want a lawyer to represent them to argue against the records being provided. So I know Aboriginal Legal Services sometimes does this when their staff is being subpoenaed, so I'm familiar with that. But are folks seeing this, and if the records get in, as they often do, then are there many lawyers who are representing organizations or the authors of records, and then do they have standing? And in what capacity?
So are you asking if the record holder has standing at a Section 278 application?
Yeah, I'm asking,
Yes.
and
Yes.
is this quite common, and are there lots of lawyers doing this? I would expect legal aid's not funding that because it's a organization, and hopefully they have.
No, so legal aid would fund the victim in that case, so their representation would be funded. However, the record holder is entitled to participate in the hearing, and and they can retain counsel to represent them, to make submissions about the privacy interests related to their records, and any other impacts that it might be on the record holder in the line of business that they do.
Okay. Is this common? Anybody else doing this? Okay, I'll talk.
Like, so sometimes, it depends, because sometimes the record holder will rely on, like, the victim's position and their counsel, which, because likely they're going to probably have an aligned position, not necessarily though, but sometimes certain organizations, we've seen this with sexual assault centers, they have, there's a philosophical basis by which they object to the records or the therapeutic records of victims being brought forward, and they would like to participate in the hearing.
Okay, thank you.
Okay, so I want to thank our panelists very much for some important information that I think everybody needs to know. Certainly trying to be as transparent as we can about this whole process, this very complicated process. And I want to thank everybody in the room who came out on a very snowy, cold Saturday morning, very early. And thank you to all of those of you, the 250 plus of you in your pajamas at home. Thank you for watching and listening. And I just have a few very quick announcements that you will want to know. The first thing is that you are going to get an email with instructions on how to download the PowerPoints that have been here. You'll get that sometime next week, probably midweek, so don't freak out if you don't get it Monday or Tuesday. We will send it to you. There will be instructions on how to download. It's a very big file, so you're going to have to download it through a private server. You'll have about five days to download the PowerPoints, and then those will be yours. The second thing is that these presentations have been webcast, and they can be watched again if anyone is interested in watching us again. Okay, anyway, they will be housed. They'll be housed for the Crowns on eLibrary, and they'll be housed for lawyers on the CLA website. And you will get an email with a link to the CLA website to where the presentations, where the webcast is going to be. That'll be again sometime next week. As you've heard, there's going to be an email that goes to you if you want to sign up for the lawyer referral list. That email will also be sent to you, and then you can click on that application with some of the questions that Brenna referenced. And then the last thing, all these great things we're giving you, if you can give something back to us, we are going to send you an evaluation form, and this just helps us determine whether this was helpful, not helpful, if you have any suggestions, and really there are not a lot of educational conferences that are sponsored by MAG and the Criminal Lawyers Association together. There have been more over the years, and I think that they're great. I think it's really nice when we can do this kind of work together and not be adversaries, but actually work collaboratively. So if you can give us your evaluation feedback, that would be really helpful for future conferences. And I want to wish everybody a great rest of the Saturday, and thank you so much for coming, and enjoy.